Any mention?
May please, Lordship. Lordship, I beg to mention this item number 31, Lordship, of the news.
Yeah.
Lordship, we were informed that the council has not been appointed yet.
Who?
For the KCDC council, Lordship. So,
Can't hear you clearly through your mask.
2 weeks
What do you
time,
say?
2 weeks time may be granted, Lordship.
What is in some council? What happened?
KCDC council, Lordship.
Malcolm Stam Mona.
Lordship.
District Council is also a party.
You're appearing for this council?
No.
You're appearing for this council?
Yes, ma'am.
There
He
he's
just
appointed.
received instruction to appear in this matter.
He's already ready with the matter, see?
No,
Oh no.
Lordship.
Oh, he came running forward. I thought he's ready with the matter. 2 weeks.
2 weeks time, Lordship. Obliged, Lordship.
My lord, item number 32, this is a contempt proceeding, my lord. In this matter, my lord, there was a direction for us to dispose of the representation, my lord. But now we find it is a suit which has to be decided by the EM revenue, my lord, not my matter. So, my lord, I am filing an application for extension of the time, my lord, where time frame was given to us, my lord. So I have taken concern of my friend. Let this matter come after 3 weeks, my lord.
No objection, Lordship.
Hello.
3 weeks request also.
Please, Your Lordship. Lordship, I'd like to mention item number 34, Your Lordship.
Excuse me. Yes.
I pray if Your Lordship can have this matter some other day, Your Lordship.
No objection, Your Lordship.
Why?
It's personal difficulty today, Your Lordship.
What's the matter about?
We want special advertisement, Your Lordship, for
Is it a
technical
small
course.
matter or a large matter? It's a small matter, correct?
Your Lordship, Ms. Colney is assisting in this matter.
Okay, after 1 week.
Similar prayer for item number 27 and 28, Your Lordship, on behalf of Mr. Paul Paske, Your Lordship.
No objection. Okay, after 2 weeks, 28, yes.
Highly
Obliged,
obliged,
Your
Your
Lordship.
May it please Your Lordship. Your Lordship, I beg to mention item number 33 on behalf of Mr. Armaja.
Number?
Number 33, Your Lordship.
3. On behalf of Mr.
Armaja. Your Lordship, may this matter come up after 1 week?
What's the matter about?
It's regarding the payment of gratuity, Your Lordship.
These matters we should all do. It's not, it won't take even 15 minutes to hear, yes, after 1 week.
Highly obliged, Your Lordship.
Item number 1.
may I please, Your Lordship, that I have a plot of land measuring about 1.5 biga. So it has been encroached by the private respondent. So make an application to the district council. So they have issued a direction to the Mondal and Kanungu and Chainman on 3rd April 2023.
Yes, where's that?
They have come.
Page 21, my lord.
They have come, but they have not served it. Again,
21.
I have made application.
Page 21, Annexure 3.
To
There are
20, my
eight-
lord, 20 and 21.
20.
20.
What do you want now?
Now I want that I pray that
Why not doing demarcation?
because they have encroached by the
No, why now this is directions given to whom?
to the Garhwil Autonomous District Council.
No, this who are these persons who are named here under notice? On top?
These are the mandals and all.
Mondal.
Okay.
Revenue officer has given a direction for
But
demarcation.
they're not doing it.
No, my lord, we have to find out, my lord, whether they are doing it or it is on the process, my lord. I am praying for some time, my lord.
Third message is a recall counsel for the petitioner. Issue notice, Mr. SD.
For 1 to 4, my lord.
Assemblies on behalf of respondent 1 to 4. Steps to be taken on the remaining respondents within 3 days. So, the grievance as
5 to 7, my lord.
the grievance of pressure is that in spite of orders directing for demarcation of his plot of land issued by the respondent number
1 to 4, my lord.
respondent number
No,
4.
they are not major party, my lord, in the proceeding. These people who has been directed.
No, how many made a party?
no,
They're
they-
your officers.
They are our officers, my lord.
Yes, but the demarcations yet to be carried out. So, according to this matter, 3 weeks for instruction, the affidavit is.
And the steps will take for respondent number 57. And meanwhile, my lord, I pray that the status quo of the land shall be maintained.
Demarcation not done. What status quo? What?
Item number 2.
Might be to your detriment.
No, they may encourage more, my
House
lord.
and make status quo.
Much of respect.
May it please, Your Lordship. Before my friend begins, Your Lordship, we have received a copy, but then the writ petition is missing from this copy. Only the annexures and the synopsis
Mr.
is
Sir, what
there.
is this? So sorry. She could have told me. Yes, Mr. Sen, please phones allowed.
Or I can give you a
1 day's time to furnish a proper copy to the common respondents. Just day after tomorrow.
Item number 3.
Where's the petitioner?
Mr. Vora, Your Lordship, he's not. Yeah, this one also is a party. Yes. Yes, respondent number 2. Then 3 is
None appears to the petitioner. Just after 1 week.
Lordship.
Item number 4.
May it please, Your Lordship. This case has a very checkered past. A very checkered past. Well, this matter has been initially, my lord, notice was issued under the Meghalaya Public Premises Eviction Act in the year 2010. Subsequent to which, my lord, some matters came before this honorable court also. My lord, a direction was given to the authorities to allow me to submit my case before the Deputy Commissioner. I did that, my lord. I filed my show cause. Upon filing of show cause, my lord, the Deputy Commissioner initially came to a finding that I am not an unauthorized occupant. Subsequent to which, my lord, the Shillong Municipal Board filed an appeal under Section 9 of the Act. When the appeal was filed, my lord, we put on an objection saying that the appeal was not maintainable. They held the appeal, the Board of Revenue held the appeal to be maintainable. I came before this honorable court. This honorable court also found the appeal to be maintainable, saying that all orders under Section 8 are appealable. Subsequent to which, my lord, we went all the way to the Supreme Court. Supreme Court upheld Your Honor's order, Lordship's order, and gave us a bracket that the fact that whether this is a public premise or not will be left open. Now, my lord, the Board of Revenue came to a finding that the order of the Deputy Commissioner was not tenable in law, and a direction was given to the Deputy Commissioner to initiate proceedings afresh, if so required. So, proceedings were once again initiated under the same Act. At that point of at that juncture, my lord, the writ petitioner realized that, my lord, she had a very bona fide dispute which she had raised. She filed a civil suit before the court. Also filed an application to waive of mandatory notice under Section 80.
Qualified civil suit is under PP Act.
My lord, because I'll place that, my lord. My case is that, my lord, I have a very bona fide dispute. I have documents to substantiate that my claim before the property, and that documents are from the year 1975. Now, my lord, in this case, my lord, the Supreme Court, if I may please just one judgment before Lordship.
Yes.
But I'll read paragraph 8. I'll read paragraph 8, my lord.
Yes.
It seems to us clear from the provisions of the summary remedy for eviction, which is provided for by Section 6 of the Act, can be resorted to by the government only against persons who are an authorized occupant of any land which is the property of the government. In regard to property described in subsection 1, 2 and subsection 2, there can be no doubt, difficulty or dispute as to the title of the government, and therefore in respect of such property, the government would be free to take recourse to summary remedy of eviction provided in section 6. A person who occupies a part of the public road, street, bridge, bed or sea or like is an unauthorized occupant of property which is declared by section 2 to be property of the government, and therefore is in public interest to evict him expeditiously, which can only be done by resorting to summary remedy provided under the Act. But in section 6.1, which confers the power of summary eviction on the government, limits the power to cause in which a person is an authorized occupant of a land for which is liable to pay assessment under Section 3. Section 3 in turn refers to unauthorized occupation of any land, which is the property of the government. If there is a bona fide dispute regarding the title of the government to any property, the government cannot take a unilateral decision in its own favor that the property belongs to it, and on the basis of such decision take recourse to other summary remedy provided by Section 6 for evicting the person who is in possession of the property under bona fide claim or title. Now, my lord, the Deputy Commissioner has initiated proceedings under the PP Act on a mere request made by the Shillong Municipal Board. I, on the other hand, my lord, I have documents.
No, but you submitted just now that a matter was taken up before the Board of Revenue,
my lord,
which found that the order of Deputy Commissioner was an error.
And
they sent it back to the correct
to reinitiate the proceedings again. So I filed my show cause again, my lord.
So that de novo proceeding.
Yes, my lord.
Yes.
Then
But
thereafter,
that means that you could not show what the materials you had to.
I did, my lord.
To
In fact, my lord,
that you are the rightful owner of that whatever.
my lord, I filed my show cause. I submitted all my documents. The Deputy Commissioner once again came to a finding that I am an authorized occupant. If Lordship will see the impian order.
Let's see. Yes.
Just see the impian order, my lord. Once. Lordship will see page 151, Annexure 32.
151.
Nothing has been discussed, my lord. I will read it out. Annexure 3. Lordship is there.
Yes.
Cases fixed today for hearing. Srimati So-and-so, represented by her learned counsel. The Chief Executive Officer, Shillong Municipal, represented through a learning counsel. Both parties present. The learned counsel for Srimati Nurjahan Marun informed that a suit was filed with the Honorable Court of the Assistant to Deputy Commissioner being TS number so-and-so along with Miss Case number so-and-so, and the same is still pending and therefore prayed for adjournment. The learned counsel for the so-and-so, well, in fact, we had not made a prayer like this. We said that give us some time to bring the documents. Of course, we have also annexed all the documents in our show cause also, but no time was given to us. Only 6 days time was given to us to submit all our documents. The learned counsel for the Chief Executive Officer, Shillong Municipal Board, submitted that on date, there is no interim order passed by the Honorable Court of the Assistant to Deputy Commissioner Shillong in favor of Srimati Nurjahan Marun. That it is further submitted by the learned counsel for the Chief Executive Officer, Shillong Municipal Board, that civil suits are barred under Section 14 of the Meghalaya such and such. Heard both parties, and I am of the considered opinion that White Memo number such and such dated 30th January 2024, the office had issued a show cause notice to Srimati so-and-so under Section 1 of Section 3 of Meghalaya Public Premises Eviction of Unauthorized Occupants Act 1980, read with Rule 3 directing Srimati Nurjahan Marun to provide reasons as to why an order of eviction should not be made. That Srimati Nurjahan Marun filed a show cause reply dated 9 February 2024, that White Letter number such and such dated 31st January 2025, this office had directed Srimati Nurjahan Marun to appear on 6/2/2025 at 12:30 p.m. in room number 306 to adduce evidence under Rule 5.2 to prove the government plot land is not a government land and to produce any other evidence, failing which the case would be decided. That upon perusal, show cause reply dated 9 February 2024, and despite being given an opportunity, Srimati Nurjahan Marun had failed to produce evidence on the date fixed for the same, that is 6/2/2025, proving that the plot number such and such Kenchis Stress Shillong is not a government land. Furthermore, Srimati Nurjahan Marun has failed to produce any evidence demonstrating how the antecedents of the property developed on her mother, late Drain Marvin. It is acknowledged that civil suits are barred under Section 14 of the Meghalaya Public Premises Eviction of Unauthorized Occupants Act 1980, and no stay order has been produced by Srimati Nurjahan Marun to stay proceedings before this office. Now, therefore, in exercise of powers conferred under Section 4 of the Meghalaya Public Premises Eviction of Unauthorized Occupants Act, Srimati Nurjahan Marun is declared to be an authorized occupant, plot number so-and-so, and is therefore directed to vacate the said government land within 15 days from the date of receipt of this order. In the event of refusal or failure to comply with this order within 15 days of receipt of this order, all persons concerned shall be liable to be evicted from the said premises, if need be by use of such force as may be reasonably necessary. Furthermore, it is directed that Srimati Nurjahan Marun remove all her personal belongings from the government land, being plot number 95, Kenchester Shillong. Any belongings left behind shall be disposed of as per applicable sections of the Meghalaya Public Premises Eviction of Unauthorized Occupants Act. Subsequent to which, I also filed a appeal before the Board of Revenue under section.
What happened to the appeal?
My appeal has not been taken up, my lord. I have told that the member is on leave.
Who's the members of this Board of Revenue now?
Also, I have to seek instructions, Lordship. I'm not aware as of right now. I'll seek instructions, I'll get back.
It has to be educated by Board of Revenue.
Well, because the Board of Revenue has not taken it up, my lord, I had no other option because 15 days time has been given to me and that will elapse tomorrow.
15 days elapsing?
Tomorrow, my lord, tomorrow.
Yes, who's appearing?
Lordship, and the appeal has been filed in March 2025, Lordship, and date is not given.
Date is not given?
Lordship, date is...
It's already numbered as Revenue Appeal number 4 of 2024.
Revenue Appeal number is not indicated here also.
Well, in my prayer, my lord, I have mentioned. Page 28.
Yes, who else? Any submission to make?
Lordship, if I can get
What instruction you'll get? Because the thing is that
Lordship,
it's a
as to
quasi-judicial
what is
proceeding that's going on. Only,
well,
I think
otherwise also,
only
my
coming
lord,
for limited protection, only that to be evicted while before the appeal is taken up for
my lord,
consideration.
at least that much.
Lordship, just get some
dispose it
instructions
off, yeah.
with regards to the status of the appeal, Lordship. Because as per the order dated the impugn order, Lordship, the petitioner has not provided any documents, Lordship. If I can take your
Forget
Lordship
about that.
documents
That
are
is an appeal. What this court wants to know is what is the last order passed in the revenue? Has it taken up?
No, my
eviction?
lord,
Where's
only-
orders passed in the by the board of revenue?
No order has been passed. My lord, only a case number has been given to us, and we've been told. We've been trying to get in touch with the people over there. We've been told that the person who's supposed to take up the revenue appeal is on leave.
How is that possible?
Lordship, may I have this matter attended to the board, Lordship? I'll seek some instructions with regards to the
I
appeal.
mean, my only prayer, Lordship has understood. My only prayer is give me some protection till the time the board comes to a decision. And also my lord, the order of the deputy commissioner, if Lordship will see, there's no, even in summary proceedings also, my lord, there has to be some adjudication. No opportunity was even afforded to me.
Who are members of the board now?
Lordship, I'm not aware, Lordship. I'll have to see instructions.
When do you get notice of this petition?
Lordship, Friday.
Then?
Friday evening. Lordship. Then,
You should at least be aware who are the members, which commissioner secretary sitting as the, chairman of the revenue board. Yes, sir. Heard Mr. Nobody anything to submit? No. Heard Mr. KCH Gautam will answer the petitioner. Yes.
Lordship, then, Lordship, the matter may be disposed of with direction to the.
Dispose it of. Exactly. Yes, heard Mr. KCH Gautam for the counsel with the petitioner. Stop Mr. H. Kharwan Lang is present, accepts notice on behalf of the respondent number
1 and 2, Lordship.
And Mr. Philemon Nobody is present, accepts notice on behalf of respondent number 3. So no further notice called for. The writ petitioner is before this court. Where's the prayer?
Page
28, Lordship.
27 to
27 to 28.
With a prayer for urgent listing and the expeditious disposal of capital MBR stroke RA capital stroke 4 stroke 2025 in accordance with law. Stop the writ petitioner, it is submitted, has been compelled to come before this court by way of the instant writ petition in view of the fact that against an order of eviction dated 6 to February 2025 passed by the Deputy Commissioner in proceedings under the Meghalaya Public Premises in bracket eviction of unauthorized occupants close bracket Act 1980. An order of eviction has been passed. By holding that the writ petitioner is in unauthorized occupation of plot number 95 situated at Kenshin Street, Shillong. Stop. Next paragraph. It's further submitted by learned counsel that an appeal has been preferred under section 8 of the said Act 1980. But however, this seems yet to be taken up for consideration in view of the non-availability of a member of the Board of Revenue. At this stage, he submits the only limited prayer that the petitioner has is for some protection until the matter is taken up for consideration and orders passed thereon by the Board of Revenue. Para Ms. H. Karon Lang, you have no objection, correct?
No objection.
Appearing for response 1 and 2 submits that as the prayer of the writ petition is limited only to some interim protection till the matter is taken up, he has no objection to the matter disposed of at the stage itself by issuing appropriate directions. Stop. Next paragraph. Similarly, Mr. Philemon Nongbri, appearing number 3, concurs submissions made by the learned counsels for 1 and 2. Next paragraph. On hearing the learned counsel of the parties on going through materials on record, it is noted that the impugn order.
Lordship, at page number 151.
151.
It is noted that proceedings had been initiated against the writ petitioner on the allegation that she was in occupation of in unauthorized occupation of plot number 95, Ganges Trace, Shillong. Stop. By the order dated 6/2/2025, the Deputy Commissioner then, on coming of finding with regard to the unauthorized occupation, had directed the vacation of the eviction, of the writ petitioner from the said premises. So, therefore, as is not disputed that an appeal has since been preferred, but however not been taken up as yet for consideration, this court therefore disposes of the instant writ application by directing that till such time the appeals is taken up by the Board of Revenue for consideration and orders pass thereon, stop, the petitioner shall not be forcibly evicted from the plot of land in question. Stop. Like that, ordered above, matter stands disposed of.
Item number 5.
Obliged.
May I please Lordship? I have instruction to withdraw this petition, Lordship.
Very good. That's why court last time said you examine it. Yes. Mr. Emar Marak today submits instructions that Mr. Emar on instruction prays that without to withdraw instant application. Yes. Prayer is allowed. Matter stands closed on withdrawal. Yes.
Item number 6.
You've taken instructions, Mr. PT.
Yes, Lordship.
So what did you decide?
Number 1, I'm a zero handicap. Mr. Professional player.
Zero handicap?
Yes.
See, last time, so what is handicap? You said that
Lordship,
he's not handicapped.
Because I'm sorry, because I really don't know, because later going only I find out zero handicap. I thought he's a disabled person. That's why I answered wrongly.
Or he's a golf pro.
Yes. So zero handicap, at that time I understood maybe disabled person.
Yes.
Later on I come to know it's a professional. Now I'm a zero handicap. And secondly, as per the condition, number 5, this petitioner, he has represented in the national level, because that page 23.
No, fine about the national level.
Yes.
But he didn't have the qualifying marks.
Yes. Another aspect is, Lordship, that the result declared, that page 33 is very wrong days, because they have mentioned there is no sports person from Garu category had been participated. That was
no sports person from Garu category maybe who qualified. That's all.
No, Lordship, there is one Garu person already, he has been selected. It's not from the Garu sports person, not from the sports person. He is from general person. There is a two vacant posts for Garu. One is for sports person. Another is not for non-sports person. So that person who has been selected, he is not from the sports category.
He's taken your post.
He has not taken my post. That vacant post is still undeclared.
Where just show that?
Yes, their lordship. I will page 32, my lord. That result, not result. Final result. Yes, page 32. So there are altogether 5 vacant posts. So one is has been selected, that Joshua Kalkongon.
W movement.
Yes, and then yes, W movement. There's only one from Garu category. As far as advertisement, there are 2 vacant posts. So this person.
Okay, Mr. Shulai.
Lordship. May it please your lordship. Lordship,
It
kindly
might
come.
be a one-horse race, but doesn't mean that he'll be appointed automatically.
Lordship, kindly see your lordship. He appeared. He did not cross the cut-off mark.
Cut-off mark, that's all.
Lordship, lordship, kindly come to page 35.
The cut-off mark's there.
Yes, your lordship. The cut-off mark is 176, your lordship. He got only 96, your lordship.
Lordship, in this matter also, I have got instruction as per the rule practically. The cut-off mark for Garo is always lower than Kasi and Genti Hills. You know, here we are.
No, but for sports it's different, no? Maybe you're more athletic
Yes,
than
here,
Kasi
here, lordship.
and Jaintia.
Yes, here, lordship. The sports person for us is 176 with 176. It should be
Lordship,
lower
kindly
than
see.
all. It should be at least equal to.
Garo 176.
You didn't score, even then you scored 96.
96
So
only,
even
your
if
lordship.
you
He
take the
failed, your
cut-off to
lordship.
be equal to 124
No,
for other sports persons, that means that you've gone below.
No, but a person who has been selected, he is not a sports person.
No, that's fine. That's another post. But one post is reserved for Garo sports person,
Yes.
one post for Khasi.
He failed to
sports person.
qualify,
Correct.
your lordship.
Now the Khasi Jaintia sports person has got appointed.
My
Correct.
lord,
now you got in 96.
Yes.
You might be good in sports, but in theory you're not good. So what to do?
No, my lord, let them, let the
Let
main
them do
respondent here, the MPSC, let them file an affidavit and regarding this, why
No,
they have
but is
make
this
a
correct?
mention.
This 35 is correct. What you've written here.
Yeah, lordship, kindly, this is a type copy from page 34.
This is a computer generated statement.
Lordship, yes.
Then
Lordship, kindly see that.
just get instructions exactly as what is the cutoff mark and why discrepancy between Khasi Jaintia and for Garos.
Then lordship, notice will go to the MPSC, your lordship.
MPSC is the main respondent, my lord.
He's zero handicap, but he should be given a chance.
He failed, your lord.
Yes, I heard Mr. P.T. Sangma, the council petitioner,
R1.
issue notice Mr. N.D. Shulai
For respondent number 1, your lord.
with so-and-so. Mr. President accepts we have number 1 and 2. Notice to issue to
1, 2, 2, 4.
1 is 3 and 4 within 3 days. This after 2 weeks for instructional affidavit.
Lordship.
Apply, your lordship.
Much blessed, lordship.
Item number
Within
7.
3 days, huh? Notice issued in 3 days, but it's 18.
Lordship.
Item,
But see, Mr. You didn't qualify, so you be prepared. Yes.
Deep down, last one.
item number 7.
What am I gonna? Who took steps for service notices 5 and 7? You took.
Yes.
Then, according to the report of the registry, you give wrong addresses.
Yes, my lord.
Then
it seems. Then when they are serving this serve this copies, then they have writing the correct one. my lord.
No, not that.
Wrong party.
The party is not even in the case. Also, you took steps on them.
So I will rectify it, my lord.
How rectify it?
Now I will delete this respondent number 5, 6, and 7.
You can't delete because they are different. 5 and 7 is different. It's like you're filing case in A, B, and C, and you took steps on someone not connected on C and D. How's that possible? That's why this court asked for from the. We thought registry had making a mistake. We thought taken to task
No.
regarding issuing notice to wrong people. But then, as per the report now, they say that white order date is so and so. It's on the was going to take fresh steps with correct address. Response 5 and 7. Subsequently, on 24 to 25, fresh steps were taken by learned counsel for the petitioner on 5 and 7 as per Talabana when a correct address was mentioned flag A. That notice was prepared. After verification, it is found that respondent 5 and 7 are not present in the court title itself. That means I have to be a little more careful. Yes, a report has been furnished by registry indicating that the error that had occurred in issuance of notice to respondents number 5 and 7 was due to the fact that the same had been supplied by the counsel of the petitioner. Stop. Like Paramis Ezarika prays that he may be allowed to submits that the error was due to inadvertence. As we have too many briefs, we'll record that.
Yes.
Due to inadvertence, and please allowed to take fresh to supply the correct addresses and take fresh steps on respondent 5 and 7. Accordingly, 1 week's time is allowed. Otherwise, you can't do this.
All right.
Item number 8.
Yes, my lord.
Sorry, sir. You want to say something?
Yes. What's for
But,
today?
we are waiting for the reply of the rubber board, and also, my lord, our objection to the affidavit filed by the Pollution Control Board. We'll be filing it in a week's time, my lord.
Who's Pollution Control Board?
I am the pollution control.
Reply their report they furnished.
Yes, yes.
Then
So we'll
you're
file a
supposed
short.
to file a reply to the report that they filed.
Yes, my lord. We require another week's time, my lord.
And number 2.
Rubber board, I'm agreeing. But in my instruction is that we are not necessary parties in the matter. We don't have to respond to this.
You know, this party, they are processing and selling rubber.
Yes, my lord.
You don't have any pervasive control over how rubber is processed also. If they grow rubber and process it, you have no pervasive control. Even you don't have actual physical control over the activities.
Your lordships.
What they told me, my lord, the dispute here is with pollution control board.
If your lordships has page 87 of the writ petition, this is a certificate issued by the rubber board. So this is important, my lord.
87. You've seen that, Dr. Mozika?
I have seen, my lord.
87.
87 and extra 16.
Yes.
That there's no manufacturing. So this is what they have to substantiate, my lord.
See, you're giving a certificate regarding pollution also.
Sometime,
Mr. Philam Nombri, the Council Representative praised for and allowed further 2 weeks' time to file a reply to the report furnished by the Pollution Control Board. Respondent number?
1 minute.
1. Similarly, Dr. N. Mozika appearing on behalf of respondent rubber boards. Respondent number? 2. Praise for and allowed 2 weeks' time to come with instructions of file affidavit. Yes, up to 2 weeks.
Deeply.
Item number 9.
May I please, your lordship. Lordship, we are not filing any rejoinder in
Yes?
this matter. We are not filing any
You're not
rejoinder
filing
in this
rejoinder.
matter. That's the matter.
What's up for hearing?
We have filed a
Yes,
affidavit.
you are appearing for different party or same?
That's for LTC. Number 2.
I'm for the state, your lordship.
Yes, party submit the pleadings complete and no submit the plea. This is a matter for hearing on so and so. Yes.
Item number 10.
We'll be filing in the course of the day, your lordship, the rejoinder.
Yes, Mr. Pasantia, learned counsel for the petitioner, submits the rejoinder file because the call is matter after 3 weeks for hearing. Any urgency? No.
No.
11.
Last order.
Yes, Mr. Panthi. Oh.
Well, it's the only issue is, insofar as the closure notices are concerned, they have gone. Now, the only issue remains, my applications are pending with the district council.
We will examine, my lord.
They can be taken up for consideration and can be disposed of.
Mr. K. Paul, who's appeared today on behalf of the writ petitioner has submitted that it is a fact that a closure notices have been since been infructuous. However, he submits that due consideration be given to the applications which are pending before authorities for renewal. Council submits that the authorities will supply,
examine,
will
yes.
study the, will
Examine.
consider the application in accordance with law.
Yes.
Accordingly, this matter is disposed of with direction that the council authorities consider the applicant the petitioner pending in accordance with law most expeditiously.
Well, its only thing is that the impugned notice as well as there was an interim order that was continuing. So now that they've withdrawn, my lords, your lordships are disposing of the matter, that there should not be any coercive action, my lords, without.
Until the matter is finally decided by the district council authorities, no coercive action of closure shall be taken against the petitioner.
Yes. Alleged.
Yes.
Item number 12.
Mr. Tanda,
Your
where's
Lordship,
Mr. Chanda? You
Lordship,
file affidavit.
we have served your Lordship to the petitioner. We'll be filing in the course of the day.
This matter is again a prosecutor matter.
Your Lordship.
Yes. MSB of Harun Letter Council for respondent number 2.
Your Lordship.
MPSC.
Your Lordship.
Submits that the affidavit be filed in the course of the day. You've seen it? You want to file a joinder?
Your Lordship, I just received.
Okay. List after 2 weeks for joinder, if any. Then we'll post it for hearing after that. Yes.
All right.
Item 13.
Lordship, in this matter, Mr. Senior Counsel Vichikanta has taken up this matter earlier.
Again?
Yes.
Now, what is the council? They're just shuffling the deck.
No,
and
because
whatever card comes out and the council appears. Because there's no proper counsel here.
Yes, Your Lordship, as of now, we are yet to receive proper instruction in the matter.
This is a Barabas Arvan.
Lordship is directed us to obtain the NOC obtained and furnished to the council. Council is yet to pass out. Be taken after 2 weeks, madam.
Correct?
Yes.
Yes, Mr. Arakasar submits that Mr. Vichikanta council's appearance in the matter. He prays that the matter be posted after
2 weeks.
2 weeks. Yes. Only after 2 weeks. Any interim order operating?
Madam, interim Lordship, interim order is there.
It's already in for the orders.
14.
Yes. Number 3, number 1 and 2. File affidavit.
Your Lordship, I have one small submission to make, Your Lordship. Your Lordship, initially in this matter, we received notice on behalf of respondent number 3 and number 4. I've already filed my power on behalf of respondent number 3, but then, well, on the last occasion when we appeared, someone has been appearing on respondent number 4, Your Lordship. So there is confusion regarding that because we have received sign along with the seal, Wakalat Nama, as well as if
number 4.
Number 4, Your Lordship.
Do you settle that among yourselves? How would you expect the court settle
No, because
that?
she has if she has.
You also got a seal and the sign.
Your Lordship, if I may submit, Your Lordship, the appointment of the petitioner was made during the tenure of SMC in which I am representing, Your Lordship. Your Lordship, on Friday itself, I came to know that there is a new SMC, Your Lordship. However, I am not a member. However, but the appointment of the petitioner was made during my tenure, Your Lordship. So that confusion is there now. If the new SMC wishes, Your Lordship, they may implead themselves, Your Lordship, or the petitioner may do so, Your Lordship.
My Lord, this issue of new SMC, my Lord, is coming for the very first time, my Lord. And I have not been informed, my Lord, because I have been representing as a legal aid for the petitioner, my Lord, and the petitioner was appointed by the CMC, the school.
Whether it's a new or old one.
Yes, my Lord.
The managing committee.
Yes,
the new
my
committee will be responsible for the actions of the managing committee also. It's a entity.
That's what, Your Lordship. In the petition itself, it has not
so
been.
So then you appear for 3 and 4.
Yes, Your Lordship. That's fine.
Yes,
my Lord, if I may submit, my Lord, my Lord, I may be allowed to implead the new SMC also, my Lord.
How you write new? You write new SMC in the court settle.
My lord, I will be, because my lord, there are new members, I suppose, my lord. Then I will.
You see, you've already implemented them. School management committee, like Nong say, you already written here. Who's prophets? What's his name?
He's the head
Prophet
teacher.
Star.
He is the head teacher, my
as well
lord.
as the secretary of the managing committee, Your Lordship.
Okay. Can't make out as professor or prophet star. Yes.
Prophet Star, my lord. Prophet Star Shila.
Okay. Yes. What to do then?
My lord, I may be allowed to implead, my lord.
Your Lordship, SMC is a body, Your Lordship. There can be only.
It may be a body, my lord, but when I was appointed, my lord, kindly see, when I was appointed, I was appointed by the school managing committee.
Which is approvals got by from the government.
Yes, Your Lordship.
Yes, my lord. Then, my lord, these managing committee which has appointed me, my lord, they are also answerable, my lord. Because, my lord,
They
here,
will support your case.
they won't support my case, my lord, but they will bring the truth, my lord, to this honorable court. The truth, my lord.
We have to implement them in person.
Yes, my lord, I will do that. I will do the
And the
necessary,
new
my
management
lord.
committee doesn't support her.
No, Your Lordship, because issue here is appointment.
That means you are 2 for 4. MS Chetri supports the petitioner and you don't.
The issue.
That's the picture. That means yes.
No, Your Lordship. The thing is, she's claiming of clearance of salary, Your Lordship.
No, forget about that.
There was
that
no-
means you don't want her. The old one wants her.
No, Your Lordship. There's no such
You
thing as
don't
that.
want.
It has to go by the rule, Your Lordship, because
Of
she
course
was
go by the
never
rules.
she was never appointed in the first place, Your Lordship.
My lord, I
Neither by
have...
the old SMC, not because it's a sanctioned post, Your Lordship, which has to be duly approved
Do
and
one
appointed.
thing. Do one thing. Whatever you file affidavits, court will consider.
Yes, Your Lordship.
I don't think you need to impede the new ones. But since if you want to, you have to file a proper application then. You want to impede A, B, C, D.
Yes, my lord, I may allowed to do that, my lord. And my lord, during the pendency of this writ petition, my lord, I have been removed from my service, my lord. And for that, I have also filed a
There was a
miscase.
need, Your Lordship. There was a need, Your Lordship.
My lord, the
Actually, if-
reason, my lord,
There was a need to remove her.
Not remove her, but then to tell her not to come to the school anymore, Your Lordship. So an official letter had to be.
Okay, one at a time. Okay, what is your case?
my lord, during the pendency of this writ petition, my lord, after this honorable court has issued notice and everything, my lord, I have been served with a petition or with a representation letter dated 1st February 2025, my lord. I have asked to be removed from my voluntarily service, my lord. And my lord, I have received this letter on the 5th March 2025, my lord. And thereafter, my lord, I have annexed in the miscase, yes, my lord. Miscase number 46 of
See,
2025.
your
my
prayer
lord.
also, you ask for release salary only.
Yes, my lord, I have, but I am in double jeopardy, my lord, here. I have also not gotten my salary from 8 years, my lord, and moreover, my lord, just because I have filed a writ petition, my lord, I have been removed from my
8
service.
years, you haven't got salary, how are you surviving?
My lord, my husband is working, my lord, so he's also looking after me.
You're very lucky then. Yes, why you discontinued her? Let her volunteer.
Yes, that's what, Your Lordship. If she is voluntarily willingly, then we will allow for her to
But is she
volunteer.
teaching or not in
But then
school?
I'm
she's
teaching,
not,
my
Your
lord.
Lordship. She's claiming salary for that for the past
Is
8
she
years.
teaching or not?
No, Your Lordship. She comes, she volunteer whenever she's free. She comes, Your Lordship, and that has been going on for the past 8 years, Your Lordship. And how
My
can
lord,
she
this
claim
is just an allegation, my lord.
Your
When I filed the writ petition, they have stated that, my lord. But the fact remains that I have been going to school, my lord. I have been teaching. I have been conducting my service very sincerely, my lord.
Okay, just 1 second. Now, just one thing court wants to know. When she was working, whatever years she worked or period, did you pay her anything or not?
Nothing, Your Lordship.
Did you pay her anything?
Nothing, Your Lordship.
From the time she started service, you never 1 rupee also.
No, Your Lordship, because it was agreed, Your Lordship, if I may put some light, Your Lordship, the petitioner here is the daughter of the teacher, assistant teacher who was appointed at that time, Your Lordship, Polan Chella. She's the daughter, Your Lordship. At the time when she was chosen to be as a voluntary teacher, she did not even have the required qualification, Your Lordship. She was just an SSLC pass, Your Lordship, class 12 pass. So she said that she will volunteer. In fact, the school and the managing committee itself has been patient enough, Your Lordship, waiting for her to clear the qualification,
Then
required
you put an
qualification.
affidavit in the
Yes, Your
miscase
Lordship,
will
we will-
consider it. Yes.
But
I think if you agree, I've not been paid 1 rupee also, then
But my lord, the fund has been generated by the government, my lord, for 2 posts, my lord. But they have not even paid me a penny, my lord.
Ms. Nongse, if you're not qualified and you have not been appointed.
But my lord, I have a certificate of DLED, my lord. I have annexed that in the.
You've not been
That was
appointed
clear in 2004.
in the proper process. That means you'll have no right because everything is stemmed from your appointment.
But my lord, the
nature of
managing.
appointment. Now you've not appointed at all, and you're just working voluntarily.
My lord, the managing committee has appointed me as a teacher representative.
Managing committee is not the right authority
Teachers
to appoint.
representative, you not give you any right.
But my lord, they have appointed me to go and teach officially, my lord. There are also annexures.
Okay. No, you let me file affidavit. Yes.
I'll file.
MS Bisun has submitted that though there was some confusion with who would represent respondent number 4, she's under instructions that he would be representative number 4, which is the new managing committee. Stop. MSP Chair 3 also has concurred to submission that she was representing the old managing committee. MS Azong said prays that she be allowed to implead the old managing committee members. Not necessary now. That such prayer will be taken up subsequently. Next paragraph, respondent number
3 and 4.
3 and 4 are ready to file affidavit in the meanwhile. Then in this case, same thing, affidavit will be filed within 1 week. You file.
Highly obliged, my lord.
Legally it matter.
Yes, my lord.
See, legally it is not for fun, no? She's just coming and filing a case. Yes.
21.
My lord, I have filed, I'm respondent number 6, my lord, I have filed miscellaneous application challenging the maintainability of the writ petition, my lord.
Where is that?
This I've received on Friday evening. I just pray for 2 days once I'll file a reply.
On what ground in challenge maintainability?
They're saying I have no legally enforceable right.
Yeah, what is your concern? It's affecting your.
I am the neighbor. My neighbor has started a construction. I have some concerns with regard to the.
How will this court decide?
I'm not asking you lordships to decide anything. All I'm simply saying, I've filed 2 complaints before MUDA. MUDA should just decide my complaints. That's all. So on that, the private respondent opposes and he says that I have no legally enforceable right. So here, my lords, if your lordship see on facts is really nothing.
It's not out of some business rivalry.
I know they are saying to say it's out of some spite. I don't understand what is the spite. They would have narrated that. There's nothing really. They've extracted.
Spite, like
no, there is no spite. They've extracted about 8 judgments. That's all.
My lord,
they really have nothing to do with the factual background.
This writ petition emanates wreaking a vengeance for whatever reasons she knows, my lord. Now, my building plans, my lord, I have waited long enough, my lord.
They've been approved by MUDA.
It has been approved. It has been approved by MUDA, my lord.
Have you served them?
Yes, my lord. We in fact served Mr. Nongri, but then Mr. Dey is appearing for MUDA now.
But the building plans are in order.
Yes.
Then.
No, that is what they are saying. We've raised certain concerns, my lord. No, we're not asking you lordships to decide.
Sit to examine the building plans.
Absolutely, I'm not asking for that, my lords. This is a matter to be decided by the technical experts. We filed 2 complaints. Let them decide and reject it.
Blocking your air and sunlight.
No, nothing.
Concerns with regard to fire safety hazards,
my lord. My lord,
these are genuine concerns. We've got that reviewed from an architect. My lord, on the last occasion, my learned friend said I've not enclosed a copy.
By you, that means he will give a review according to you.
No, so that's what I'm saying. They may dismiss my application also. I've raised 2 complaints. Let the MUDA dismiss it.
Yes, Mr. Dey.
Number of occasions they have filed a complaint, my lord.
Let you dispose it off. We'll dispose of this matter here and now.
Lordship, that's all. Number of occasions, my lord. They have lodged a complaint. We try to address, my lord. We've conducted spot inquiry. Always, my lord, on one pretext or the other, my lord, they don't appear before the spot inquiry commission, my lord, or inquiry officer, my lord. How can you decide, my lord? Even if now, my lord, we want to have a fresh inquiry, my lord, they will not come, my lord. They will not communicate. My lords will give a direction to dispose of within 2 weeks. If I don't participate, they may dismiss it.
You see, the thing is that court owner doesn't want to be a vehicle or something like to settle.
Yes. No, I completely understand. Like let MUDA decide it, my lord.
If you have a genuine grievance,
it is a genuine grievance, my lord.
Yes, you know.
Yes.
It is a genuine grievance. But my friend says there is some spite. What is the real spite? He's not really
No, my
addressed that
lord,
at all. Nothing has been revealed in his application. Nothing has been revealed.
My lord,
he says out of some vengeance. What is the vengeance really?
No, somebody, my lord.
Court doesn't want to know also.
Yes,
Exactly.
my lord.
I understand.
File a small affidavit, my lord, showing the conduct of the petitioner.
Yes.
Very well.
Yes, my lord.
All I was saying, my lord, this could save the time of the court. They can just dispose of the complaints.
Number is here.
Miss case number 50, my lord. 50.
What is it?
50, my lord.
50.
25 will file in the connected petition challenging the maintainability of the on a ground maintainability. So this is the miss case, no? Mr. SN prays for 1 week's time to file reply to the same, reply to the objection. So, in the main case, Mr. SD appearing for respondent number.
Yes, respondent number 124.
My lord's Muda is.
Muda
is 4 and 5.
4 and 5.
4 and 5 also praise that he be allowed to. How much time?
2 weeks I will file.
To file a short affidavit. Stop. List the matter for 2 weeks. Miss case list together also.
May I just point out, state has already taken cognizance of my complaint. They have already deputed somebody, but so far spot inspection has not been carried out.
No, but see, autonomous authority is there.
Correct, correct. Ideally, Muda would be best suited.
It's not a question of, see, one thing, Mr. Sen, we can understand if it's unauthorized construction as a concerned citizen, also as a neighbor, also maybe he might be affected. But if, as what Mr. Yuban submitting, that this construction was, had commenced on sanctioned building plans, so then what will we interfere?
I'll satisfy my lords on the basis of my writ petition as well, and on the basis of the review report which I have from the architect. No, absolutely not.
On law.
Not on that at all.
22.
Oblige me.
This matter relates to transfer and lordship. My lord's order 10th March 2025, lordship, some observation.
So for the instruction course, your lordship, there is no administrative post, your lordship. So that's why he has been brought back, your lordship, and in view of the fact that the post which he was holding, your lordship, is a girl institution, your lordship. That's why he has been.
No, of course, I mean, put him some other post, not in the school where he was.
Lordship, if he wants, your lordship, then we can consider placing him either in Joy or Nostoin, your lordship.
Yes, you go to Joy.
Lordship will.
He came from Joy also. He was serving in Nostoin, thereafter transferred to Joy.
Then we can.
He came here.
Going homecoming for him.
Okay.
Lordship, I'll have instruction, your lordship.
Mr. Andishulai submits that the transfer was necessary due to the fact that the writ petitioner was serving in all girls school. However, praise him allowed some more time to obtain to obtain such the respondents to whether it can be placed in Nostoin and Joy.
Or Joy, lordship, yes.
Under my humble submission, even in Shillong, vacancy is there. And the complaint has no connection with the
whatever
school.
it is, it's a transfer is not our. Court can't order like transfer you here or there.
Apply a lordship.
Yes.
Well, since the interim order we prayed for, and interim order is not yet. Well, lordship consider.
The primary respondent has already joined. She has already assumed charge.
Other teacher may have joined, my lord, but with regard to my transfer, I'm yet to join. So there will be confusion again.
Within a week from today.
Lordship, yes. Apply, lordship.
23.
Instruction will be received a week from today. Sorry.
Apply.
My lord, this is 20.
Tired of this case, Mr.
23. My lord.
My lord, yes, my lord, I have made her understand at that conclusion, my lord, he requested at least 8 lakhs, my lord, may be considered.
8 lakhs.
My lord.
8. My lord, I'll take instructions, my lord. So far we got 2 lakhs only, my lord. I'll take instructions, my lord. A week's time, my lord, I'll take instructions.
Case Kashi and counsel for respondent 1 submits that the respondent do entitled to much more in order to bring a quietus to the issue is willing to accept a sum rupees 8 lakhs only. Stop. Next one, Mr. Priya will please will have to update instructions on the same. It's up to 2 weeks. It lasts not a big time nowadays.
My lord, obliged.
To sell the goats and the sheep.
Obliged.
Hello,
24 also is connected. 24.
Item 15.
Okay. Huh? I just yes. Just give me 5 minutes. I'll just come back. It's a lot of congestion. 5 minutes. Yes.
Just take out Kashyap's second.
Your last submission was on 18th?
My lords. Thereafter, my lords had fixed a date, but that day some other matter was taken up, my lords, and the matter came up.
And you ran away.
I had some personal difficulty.
Yes.
I'll try and wrap it up, my lords, in 15 minutes. I'll not take too long. 15-20 minutes. This is the thrust of my submissions, my lords, I've already made.
Yes.
Well, it's what I had submitted before your lordships, my lords, just to refresh, my lords, memories. I had submitted, my lords, that this power that was exercised by the commission, my lords, was not suo motu. It was on the basis of an application filed by the distribution licensee. That's the first matter. The second thing, my lords, I had submitted is that there cannot be any inherent power with the commission, my lords.
You said, okay, there's no inherent power, there's lack of jurisdiction which is palpable, and then regulation is silent as far as the recall is concerned.
My lords, that they admit.
Yes.
They admit that it is silent.
And so you say that inherent power is invoked, which was never the case.
It cannot be, my lords. It cannot be. My argument is this, that because when we had filed a writ petition before this honorable court had sought specific instructions as to what power was being exercised. It was categorically pointed out by the commission that we are only entertaining the applications filed by the MECL. It is not a case of, my lords, the commission at some point of time realizing that there was some mistake or error apparent on the face of the record, or palpable error on the face of the record, which warranted, my lords, reconsideration of that order.
Yes.
It was essentially on the basis of an application that was filed by MECL. Now, initially a challenge was made before this honorable court, my lords. Subsequently, that challenge was withdrawn with liberty to go before MECL. Application was filed and it was heard, and an order has been passed. Now it is being contended by the commission that it was in exercise of its inherent powers. What I'm humbly submitting before your lordships, my lords, that in view of the categorical instruction that was placed before this honorable court, it cannot be a case of exercise of inherent powers. They were exercising powers of, my lords, the application that was filed by, of deciding the application that was filed by the distribution licensee.
Yes.
So you cannot take a U-turn later and say that no, I have exercised my inherent powers.
Yes, you're limited to that, right?
Logic.
Yes.
In this context, my lords, there's one judgment that I must place at this juncture. Well, this is a judgment of the Constitution Bench of the Honorable Supreme Court with regard to this question of jurisdiction, my lords. This is 1964. This is, my lords, I'll give the SCR citation, 1965, 1 SCR 413. There's a compilation, my lords. I'll just please give them a copy. You've got a copy. Somebody for the commission.
No, which one, 19?
My lords, this is 1965, 1 SCR, page 413. Your lordships would find it at page 30 of my compilation.
(1965).
Page 30, if my lords kindly come.
Right. This is, yes.
This is that Keshav Singh's matter which was decided. Of course, here the cost title is different. Well, it's powers, privileges and immunities of state legislature. It was a reference that was made, and decided by a 7-judge bench. I'll not go into the merits of this matter, I'll take your lordships to page 98 of the compilation, paragraph 136.
Yes. Yes.
May I read paragraph 136, my lords? we ought to make it clear that we are dealing with the question of jurisdiction and are not concerned with the propriety or reasonableness of the exercise of such jurisdiction, as is the case here, Milits. Besides, in the case of a superior court of record, it is for the court to consider whether any matter falls within its jurisdiction or not. Unlike a court of limited jurisdiction, the superior court is entitled to determine for itself questions about its own jurisdiction. Prima facie, says Halsbury, no matter is deemed to be beyond the jurisdiction of a superior court unless it is expressly shown to be so, while nothing is within the jurisdiction of an inferior court unless it is expressly shown on the face of the proceedings that when a particular matter is within the cognizance of the particular court. So the ratio that they lay down is, in cases of a superior court or a constitutional court, everything is within the jurisdiction of the court unless, there is a specific bar to the entertainment of a proceeding. Quite on the contrary, everything is outside the jurisdiction of a court of limited jurisdiction. I will not use the term inferior, limited jurisdiction, unless it is expressly showed, that that power is available with you.
Yes.
Now, the fact of the matter remains, that insofar as the MSCRC is concerned, that power is unavailable and is admitted by the Commission, that power, at least expressly, is not laid down in the regulations.
Yes.
I'll draw your Lordship's attention to the regulations. Excuse me. Your Lordships kindly have the regulations.
From your compilation itself?
These regulations, I think, were filed separately by way of a... It was filed earlier, a copy was made available to this Honorable Court. It will be a book like this. We had prepared, with all the... for assistance of this Honorable Court in all matters. Just assist the court with this. I have an extra copy, for the time being. I'll just place it. We'd made a compilation and filed it, There are a lot of electricity matters coming up. So, my lords had also made a query at some point of time. I'll just quickly just take your Lordship. My lords may come to paragraph 17.
Page?
I'm sorry, page 17, my lords.
70.
17. This is the conduct of business regulations, my lords.
Oh, yes. Yes.
Now, I'll first take your Lordships to page 24, and my lords may kindly have a look at 26. Regulation 26, my lords. This is where they say that the power of recall emanates from. Now, my lords, may I read this? Nothing in these regulations shall be construed as barring the Commission from exercising its power under the Act, for which provisions have not been made or have been made inadequately in order to subserve the spirit of the Act. In my humble submission, my lords, the portion after the comma is the part that clarifies this entire paragraph, that it says, it should not limit the powers of the Commission in order to subserve the spirit of the Act. So, my lords, what I had initially submitted before your Lordships is that the Commission, being the creation of a statute, my lords, would essentially have to exercise powers within the four corners of the statute. Now, if these regulations, my lords, are incomplete with regard to some power which has already been given under the Act, to that limited extent, my lords, this is a savings clause. Not to
frustrate the spirit of the Act.
It's a savings clause rather than a clause which gives inherent powers to the Commission. And I pointed out, my lords, from the judgment that was quoted by the Commission while passing the order, the distinction between, my lords, the inherent powers which were given to, my lords, NCLT, and, my lords, the powers that have been given to the Commission.
Yeah.
I'll very quickly just refresh that. Just take your lordships to the judgment. Yeah, just give me the writ petition. It's there. If my lords kindly have the writ petition, my lords, the impugned order. Because there they've referred to, my lords, that Noida decision, and I'll come to that Noida. Well, let's say my lords have page 177 of the writ petition, paragraph 57 is where that power of NCLT, my lords, is reproduced.
Yes.
This is, my lords, from that Noida matter, which is the, my lords, the judgment on the basis of which the Commission says that I have the power. Now, they have referred to paragraph 57, my lords. This is while deciding the issue and holding that NCLT had passed to recall its orders, the Honorable Supreme Court dealt with Rule 11 of the NCLT 2011 rules, which is reproduced below. Nothing in these rules shall be deemed to limit or otherwise affect the inherent powers of the tribunal to make such orders as may be necessary for meeting the ends of justice or to prevent the abuse of the process of the tribunal. Now, well, it's this, by no stretch of imagination can be said that any such power is now vested with the Commission.
Okay.
Because these rules, my lords, provide for inherent powers. That yes, in these circumstances, the Commission has the powers of doing substantial justice between the parties. Because it is in the facts of this matter, my lords, it is in the tribunal had initially said, my lords, that we do not have the power of recall. Honorable Supreme Court says that on interpretation of Rule 11, my lords, that no, this invests you with inherent powers.
Yes.
So no such kind of, this kind of language, my lords, is
used in the regulation.
In the regulations, insofar as the Commission is concerned here in Meghalaya. So therefore, my lords, it cannot be said that these powers are available with the Commission. I've pointed out, my lords, what are the inherent powers available with the Commission insofar as Shillong is concerned, insofar as Meghalaya is concerned. Now, this, my lords, further stands buttressed by, if my lords kindly have a look at Regulation 21. My lords, this is the power of review. Now, this also opens up with a very interesting, my lords, phrase.
Yes. Review decisions.
My lords. May I read, my lords?
Yes.
A person aggrieved by a decision or order of the Commission from which no appeal is preferred or is not allowed to be preferred can seek review of the order if new and important facts which after the exercise of due diligence were not within his knowledge or could not be produced by him at the time when the order was passed, or on account of some mistake or error apparent on the face of the record, or for any other sufficient reason, by making an application within 60 days of the date of the order. Now, this power, your lordships will kindly see, cannot be suo motu exercised by the Commission. It is only on an application made by a person aggrieved.
Yes.
Which again, my lords, would go on to, my lords, suggest that independent powers, my lords, are not available with the Commission. There is no inherent power available with you. If somebody is aggrieved, they can come to you. Then you will deal with it, my lords, under these conditions, and then you will decide it appropriately.
Yes.
Well, it's the thrust of the objections, my lords, that have been raised before this honorable court by the respondents is, my lords, that there is an alternative remedy under section 111 of the Electricity Act. Now, my answer to this is, my lords, and which I had indicated on the last date, is that here the essential question is the question of exercise of jurisdiction by a commission.
Yes.
And contrary to what is submitted by the commission before this honorable court, my lords, that it may not be a case of quorum non judice, but it might have been a case of irregular exercise of power that by itself will not confer jurisdiction to this honorable court. It can be decided in an appeal. What the petitioners are arguing, or what I am submitting before your lordships is, my lords, that power itself is not available. Now, once, my lords, I take a plea that the power itself is not available, then, my lords, the question of the matter going before an appellate tribunal cannot be, my lords, would not be an efficacious alternative remedy.
Okay.
Because the question of whether somebody has the jurisdiction, it is a question of interpretation of
whether appel can go into this question.
My lords, in my humble submission, my lords, it cannot. Because the question is here is whether that power is available with the commission in the first place or it is not available. Had it been a case, my lords, of what was being suggested before this honorable court by the commission, that it is not a case of that power itself does not exist. Now, their argument for saying this is, they say that we are the authority which fixes the tariff. So therefore, even if we passed any order, my lords, that is a matter which can be taken up in appeal before the commission, before the APTEL. What I am submitting before your lordships is there is no dispute that you are the authority which fixes the tariff, which is why, my lords, your lordships have relegated us in the first place to the commission. Now the commission, rightly or wrongly, has exercised a power. I am saying that the power to...
The manner of exercise.
No, I am not on manner of exercise, my lords. Mr. Tiwari had gone on manner of exercise. I am saying that that power itself is not available to you under the regulations. And to that limited extent, my lords, there is an admission from the commission that at least expressly it is not available.
Yes.
Once, my lords, there is an admission by an authority that expressly it is not available, and in view of what I have pointed out in Keshav Singh, my lords, that a constitution bench of the Honorable Supreme Court has laid down the law. So, irrespective of what are the judgments that have come subsequently, my lords, that will not have a bearing insofar as this aspect is concerned, that they would have to demonstrate that yes, this power is available with me. The moment you are a court of limited jurisdiction, my lords, you'll have to show that yes, this power is available with me. Under this, I have done it. Yes. They say, my lords, they have done it under 26. I have pointed out before your lordships, my lords, 26 does not invest you with that power.
Yes.
So, in these facts and circumstances, my lords, I would humbly submit that APTEL would not be an efficacious alternative remedy, number one. Number two, my lords, this matter involves the interpretation of the law insofar as the regulations are concerned vis-a-vis, my lords, the judicial pronouncements. So that is a matter that would have to be essentially addressed by this honorable court.
Yes.
So the plea of, my lords, 111 would, in my humble submission, not come into this. So with the Electricity Act.
Yes. I see.
These are general powers of appeal under section 111. My lords may kindly have a look at it. Well, it's 1116 meant to a limited extent, my lords, be relevant for our purposes. Subsection 6, if my lords can have look, my lords. The appellate tribunal may, for the purpose of examining the legality, propriety, or correctness of any order made by the adjudicating officer or the appropriate commission under this act, as the case may be, in relation to any proceeding or on its own motion or otherwise, call for the records of such proceeding and make such order as it thinks fit and proper. So it is, my lords, legality, propriety, or correctness. To sum up the powers under 111, my lords, I would say that is legality, propriety, and correctness. Here it is not a question of, my lords, being limited to these issues. It is a question of whether a certain power is invoked by a commission, my lords, whether that power is available.
They have advanced that appeals available to any order that's passed by the High
No,
Court.
no, I am not on that, my lords. I am taking it a step further.
We understand.
They say, my lords, any order can be
can be passed at all.
Now, what I am saying is, what is the power, what is the scope of power to be exercised by the appellate authority? Which is why, my lords, I took the liberty of taking your lordships to section 6, subsection 6. Now, the language used in subsection 6 says, my lords, legality, propriety, or correctness. Though these are very broad definitions, my lords, but the fact of the matter remains that here the question is, my lords, whether a power is available with you or not. So that by itself, my lords, my humble submission before your lordships would be, my lords, that by itself would not, even though, my lords, it is a very broad compass on which the powers are to be exercised by the commission, the fact of the matter remains, my lords, when a question of jurisdiction is there, my lords, this honorable court may not, my lords, just throw me out only on the ground that there is an alternative remedy, because it may not be an efficacious remedy.
Okay, you argued that, yes.
Lordships. And that, my lords, again, I would be saved by Whirlpool, because in Whirlpool also my lords have taken a similar view that where my lords, I'll just take your lordships to Whirlpool, my lords. This is in our compilation?
Yes, it's there in the compilation.
My lords. Page 212. My lords have it, my lords. Paragraph 14 and 15 at page 212.
Yes.
Then I'll just quickly read paragraph 14 and 15. The power to issue prerogative writs under Article 226 of the Constitution is plenary in nature and is not limited by any other provision of the Constitution. This power can be exercised by the High Court not only for the issuance of writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, for the enforcement of any fundamental rights contained in Part 3 of the Constitution, but also for any other purpose. Under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that if an alternative and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has consistently held by this court not to operate as a bar in at least 3 contingencies, namely, where the writ petition has been filed for the enforcement of any fundamental rights, or where there has been a violation of the principles of natural justice, or where the order or proceedings are wholly without jurisdiction.
Yes.
Wholly without jurisdiction, or the virus of an act is challenged. So, my lords, the minute the question of, my lords, jurisdiction comes in, or the plea of alternative remedy, my lords, in my humble submission, will not come into the assistance of the respondents. You will not shut me out, my lords, merely by saying that there is a remedy of appeal, and you go and exhaust the remedy of appeal.
Yes. Yes.
No, my lords, if I may pause here for a second. My lords, insofar as this plea of alternative remedy is, my lords, I have placed what is the arguments of the petitioner before your lordships. Now, the rest of the submissions, my lords, including what has been advanced by Mr. Tiwari, are on the merits of the matter. Now, if your lordships so please, my lords, I can continue with the merits of the matter.
Merits, it's something, because the thing is that you attacked a core issue, that's the only thing. To show that why this court has to interfere, that's why. Otherwise, to persuade the court rather that, But then how do you address the earlier division bench orders of this court? There's a division bench order of this court with regard to, that remedy under...
I will just deal with it. I think that's a matter where I have appeared.
Yes, you have appeared. And so that is what...
I will take your lordship.
I guess the orders of this court where interference was...
in
single bench, some orders were passed which taken an appeal.
My lords, that were in different facts and circumstances. There, the question of jurisdiction was never an issue. If I remember
back my mind, because if the division bench order exists as it
in the facts of
we are bound by it.
No, my lords, absolutely. I would bow down, and I am a party to that proceedings, my lords. I will have to assist your lordships.
Yes.
If I remember correctly,
clarifying that part.
If I remember correctly, my lords, what had happened to the compilation
order
by the state? What had happened, my lords? That is the special tariff matter. What had happened is, my lords, initially there was an agreement between, my lords, if I'm not mistaken, between the BIA and
the MOU.
Yes. And your lordships had held that that power is not available for them to walk away from that, my lords, especially since the commission had already, my lords, ratified the MOU in its tariff order.
Right.
That was the facts of the matter. So we had come for enforcement of that. Your lordships had held that they cannot walk away from it. They are bound by it. Matter went up in appeal. Appellate court, my lords, took a view that it would not be directly for this court to take view of the my lords, cognizance of this matter, in view of the fact that there is the MSCRC, which is under the Act, my lords, is the appropriate authority to deal with this issue. I'll take your lordships through both those two orders. That is at Annexure R8, my lords, at page 80.
Oh, you read petition?
My lords. No, my lords. This is counter affidavit filed by MEPDCL.
Oh.
They filed a compilation also with it. No. Not this. I'm sorry, my lords, not this. Lordships, my.
Order is at page 80, my lord, of my counter affidavit also. Page 80.
If I don't know if this is what my. I don't think this is the one, my lords. No, this is not the one. I'll take your lordships to the main judgment.
This is by power distribution versus.
This is when they came before the, my lords, they went before the division bench, and the division bench says that no, you go before MSCRC. This, my lords, would not be the preposition that my lords are saying. The operative portion of this is, my lords, at paragraph 7.
Where's the order then?
I'll take your lordships. I know what your lordships are referring to. Lordships, just bear with me for a second. Where's the one that has been filed by, let me see. No. Wait. Just, my lords, just bear with me for a second. I know exactly the order that your lordships are referring to. This is with regard to special tariff. Let's just bear with me. Here.
Just matter so you were there.
I was there, my lords. I was attending. My lords, that's why I pointed out para 15 of Whirlpool.
Of course, it's wholly raw jurisdiction, fine.
My lords, because that view has again been that view has again been reiterated by the division bench in some other proceedings also.
In this matter also at page 80,
Lordship.
they reiterated that.
Lordships.
So
that ordinarily
that order just comes to mind because
that order was only on the ground, my lords, because the question of jurisdiction.
If I remember correctly, this court interfered.
My lords,
right?
Matter went up in appeal, my lords.
Said that a single bench should have, I think.
My lords, the division bench takes a view that this matter being within the cognizance of MSCRC, my lords, should have been taken to MSCRC rather than coming before a writ court, and they relegate us to a writ court without expressing anything on the merits of the matter. That's it. I'll point out the judgment, my lords. It is available with me.
Yes, anything else? Let them reply.
Well, it's insofar as alternative remedy is concerned, this is the issue. The other arguments, which are there in the, I've seen in the written arguments that have been filed before your lordships.
Written arguments has been filed?
They filed some notes of arguments. At least I have copies of it.
What is this file?
Just take it.
While I was placing my argument, I placed a note for final hearing, if your lordship will have, this is 4-page bullet point kind of thing, and I was referring to this bullet point through which I placed my case. So my friend is referring to that.
Okay. Oh yes, okay, yes.
I think this is what my learned friend is also referring to. And so, my lord, so has also the commission has also filed a 4-page note.
This is where's the one file? Commission. Stuck another might be stuck in Mr. Tiwari's file.
Mr. Tiwari's file, because judgments compilation and everything.
My lords, it is no.
Stuck in other matter.
My lords, because it is filed in WPC number 339 of 2024.
No, but it was placed in the
other matter where your lordships have concluded the matter.
Yes.
That's okay, my lords. I can just very quickly just refer to this. My friend has a copy. Because what I submitted, my lords, at this stage, my lords, I'm putting a pause to my arguments. Because if, my lords, my initial argument of this honorable court, my lords, not entertaining us on the plea of alternative remedies concerned, my lords, if is not accepted, then, my lords, nothing would survive for consideration for the other issues. Which I think what Mr. Tiwari has done, my lord, he has gone through he has argued the entire matter in its entirety. Because if I were to go into, my lords, section 83, 84 and the other things, my lords, that would be on the merits of the order that has been passed. They have raised the initial, my lords, objection that this honorable court will not entertain us because there is a plea of alternative remedy. Now, in addition to this, my lords, I think insofar as, my lords, the MECL is concerned, they have raised another 2 arguments. Now, my lords, one of the pleas that they take is they say that the petitioners, having participated in the proceedings before the commission, cannot turn around and challenge its order on the ground of inherent lack of jurisdiction.
Having participated in proceedings.
Marriage.
Okay.
Now, insofar as, my lords, this issue is concerned, there are 2 answers to it. First, my lords, that what your lordships are dealing with in 339 is not the subject matter of the order of 23/8/2024. And, my lords, it's very important if I can take your lordships to that, because the argument itself is, my lords, self-defeating. I'll just read it, my lords. They narrate, my lords, the sequence of events as to how the proceedings came before this honorable court. Your lordships relegated us, my lords, and in paragraphs 4.9.
Can we have that? But no, we'll need that piece of paper.
I'm sorry, my lords, I just have 1 copy, or else I could have assisted your lordships.
The files are here.
Oh, my lords, may I just continue tomorrow? Because what I've submitted before your lordships also, I'll reduce it into a 1-page bullet point and give it to your lordships. I'll reduce my arguments also to a 1-page, my lords.
So what will happen is that the one that I heard, they've tied it up and...
My lords, must have gone for. Because that's been some time, my lords, because it's been over a month that the arguments have been... I'll just read 4.9, my lords. Your lordships will understand. It is therefore seen that the petitioners did not submit to the jurisdiction of the commission and never participated in the proceedings which culminated into the impugned order dated so and so, by which the earlier tariff order was recalled. So the moment they say, my lords, I did not submit, matter ends.
You did not submit to the jurisdiction.
I did not, because I came before your lordships, my lords, saying that the commission does not have power. Your lordship says that whatever pleas you have, you go and take it before the commission, let them decide it. After that, we will decide it.
Okay.
So, my lords, the fact of the matter remains...
You maintain that you are not...
It cannot be a case, my lords. I came before your lordships. I said that when the initial notice was issued by the commission, my lords, I came before this honorable court and I said that MSARC does not have this jurisdiction. It is on that matter, my lords, had sought instructions as to what power is being exercised. Is it a power being exercised suo moto or it is a power on the applications? They said it is on the applications. I said they cannot entertain the applications. Your lordship says, go back to the commission, raise whatever issues you want to, let them decide that. Whatever is the decision, that will be the subject matter to be, my lords, appropriately examined in an appropriate proceeding. So this is the appropriate proceeding.
Okay. Yes.
Now, my lords, insofar as 5 is concerned, 5 is again with regard to these 2 new writ petitions.
5?
Bullet point 5, my lords. Okay. I'm sorry, my apologies. This is with regard to 5 is with regard to the fresh writ petitions which are in the orders column. I'll not need to address this at this point of time. This says, my lords, that because I made the payment, so there is a waiver on my part. My lords, that in my humble submission cannot be answered in this writ petition. The answer to this is very simple, my lords. When I made the payment under orders of this honorable court, my lords, it's very specific. That it is under protest, that whatever payment under orders of this honorable court we are making. So that cannot be construed as a waiver in any case. And these, well, it's, in my humble submission, my lord, would be very superfluous in view of what is the principal challenge before my lords. Then is, my lords, on suppression of material fact, filing of 2 writ petitions. These, my lords, in my humble submission would be very superfluous because your lordships are dealing with a much more graver issue while deciding on the, my lords, the jurisdiction of the commission. What I can do is, my lords, I can come back tomorrow with my bullet points and, my lords, the law that I placed before lordships, including, my lords, the judgment that my lords were referring to.
Let them reply.
Let them respond, my lords, to whatever I have submitted.
I thought we could conclude it today. Yes.
My
lords, before my friend begins, one second. My lords, may kindly excuse me for a little while.
It doesn't matter.
I'll take only hardly 5 minutes, my lord. Nothing much is argued. Only 2 points have been argued to my limited understanding. One, my lord, what is being said is that the commission has conceded or said that it has no inherent power. And the exercise is being carried out on the application filed by the distribution company.
Right.
That is what the first.
Yeah.
Now, so far as the fact your lordship would recall, that it is a fact that the application was moved before commission by the distribution company.
Yes.
So, on my application, the commission has exercised the power. So, saying something that the commission has no inherent power, commission did not say that it is not, commission said that it is not exercising suo motu power. It is exercising power on the application moved by distribution company.
No, the other part, Mr. Arfi General, is that with regard to the forum, now they're saying that whether that's an exercise in review, because when that order which you agree with was signed by only 1 member, correct? And then the matter was sort of objected to, you file applications again, and the matter was signed by 2 members. Which is like, which would make it valid. Now they are saying that you didn't have the power to review, and you reviewed that order made by 1 member by holding that the 1 member was incompetent to pass the order. And secondly is that if the discourse or the proceedings were to be limited only to your applications, then they have exercised inherent powers in correcting the entire what you felt was the defects in the earlier order and rehearing the entire de novo is.
Yes, now,
if I understand correctly, that's what I will examine it. But then that is the trend of the arguments.
That is the crux of the second part. First limb, my lord. Now, second limb of the argument of Mr. Paul, London Senior Counsel is, my lord, as rightly put by your lordship, is that the first order was passed by one who hears must decide the matter. That is the first principle. The matter was heard by 2, it was decided by 1, and it is against the law. The commission has taken a view that it is non-est. Commission has taken a view based on the precedents of Aptel and all, my lord.
Right.
That those decisions I have referred to, my lord, Damodar Valley, to every lordship would recall, that the commission singly could not have decided. Now the question is, which They say that no, my friend is not disputing the fact that commission has power to review or recall its order, because one statutory provision would be sufficient, my lord. If your lordship will see section 64(5), my lord, I need not trouble with your lordship with other provision, but section 64 of the Electricity Act, subsection 6, my lord.
Yes.
A tariff order shall, section 64, subsection 6, a tariff order shall, unless amended or revoked, continue to be in force for such period as may be specified in the tariff order. So, unless amended or revoked, first it has to be a tariff order, my lord. There is no tariff order because single member has no power to pass the tariff order, my lord.
Yes.
And for that purpose, my lord, kindly see the regulations which my friend has referred to, my lord. I will go by law only. And if your lordship will see, I don't know compilation, there is some problem with the compilation, my lord. But if your lordship will see the compilation and where MYT regulation is there, it is part of my counter affidavit also, my lord. The regulation is very clear, my lord. There is no ambiguity in the regulation. And if your lordship will kindly come to page
on.
Because there is so many compilations which have been filed, Lord. And I'm sorry because in the MYT regulation, if your lordship will see, that regulation is very clear. And simply, your lordship kindly take note of the provisions of the regulations only, my lord.
Yes.
Which is in my our regulations are, my lord. If your lordship will see, just give me one moment, your lordship, because there are now. Problem is that when both the matters are heard separately.
That is a problem which is court facing also, because now court forgotten what Mr. Tiwari argued. Mr. Tiwari had made such a long argument, and now the same matter. Then like only thing that when this matter was taken up by Mr. under Adamas Mr. Paul, because it's not available, I thought there will be a supplemental arguments, not the entire new line of argument has been taken. Because the line of argument taken Mr. Tiwari is at divergence with the arguments made by Mr. Paul. So this court, when generating a judgment, what will it do? Record two separate arguments and two separate replies, and try to make them come together, and
The difference is, my lord, there are three arguments before your lordship in this case. Difference in the first argument and second argument is not much of significance for the simple reason, my lord. In first, Mr. Tiwari argued, he said that single member was competent to pass the order. That is the argument which was London Senior Counsel Mr. Tiwari advanced. My friend is saying that Mr. Paul is saying that no, he has the power. In fact, he is saying that Commission has the power to review its own order, but it can do it in certain circumstances only. For that, MYT regulation was referred to, my lord. And for that purpose, my lord, if your lordship will see that the order passed by single member is inherently lacking in jurisdiction, wholly without jurisdiction. And the Commission at page 168, if your lordship will see page 168 of the impugned judgment, he has given cogent reasons. And whether those reasons can be tested in the appeal or not is the question which falls for a lordship.
168.
168. It will be one page 168. So there are so many volumes now. I'm also confused. Where do I go? Yes, lordship will see page 168 of the order, my lord.
Proceedings. Then again we come to section 92 and 93 again regarding to vacancies. So we're coming around full circle again to the argument Mr. Tiwari. So you could confusing this court more.
The issue is, if you lordship, the issue.
If we're going to address Mr. Paul's arguments, then we stick to that. That in the total lack of jurisdiction, which he says, that is just one of the three things which you can. A red court will exercise jurisdiction. It would, like the alternative remedy, not be efficacious because this wholly law jurisdiction. There was nothing in the regulation or in the act provides for the action that the commission has done. That's the thing. And now you go back again to, I think 93 was argued by Mr. Venkatesh last time, right?
My lord, leave the.
So I mean, like
Lord.
you're just making this court run around
Can we
circles again.
see whether this order can be tested before the appellate authority or not? Can we see section 111, my lord? That's the only thing.
Section 11 says any orders passed by the commission.
By any order passed, and division bench order of this honorable court is very clear, my lord.
I want to see the other division bench order. They don't have it with them.
Page 80, my lord, page 80 of
Page
my
80 is
counter-
regard to the other one you file against the commission, where the same the thing.
The division bench has said in that, my lord, it lays down the contours of interference in the writ matter, my lord. Kindly see paragraph 7 of the page 80.
I remember it says that should appear without wholly or jurisdiction or appear meanness or something like that.
Yes, wholly without jurisdiction or absurd to the meanest mind.
Yes.
Absurd
Absurd to the
to the
meanest
meanest
mind.
mind, my lord. Yes, so, my lord, is it a case of wholly without jurisdiction, my lord? My friend is not saying that it is not wholly without jurisdiction.
So one
My
thing,
friend is
Mr.
saying
Advocate
it-
General, we'll do one thing. If you can condense, your arguments, like
Yes,
I've got
Lord.
handicaps, I don't have your other notes, which are in the other file. But if you
Yeah,
can just
I'll-
condense it,
I'll put it, my lord.
if you can condense it, and just
I will
encapsulate
do
it.
that, my lord. I will do that. I will do
Because
that.
Mr. I think
understand
from the
the-
side of the commission, it's been quite concise with addressing that 93 whatever with regard to the forum and that vacancy position and
Yes.
92, 93. So
I'll put one concise note, my lord, in BIA also, which I have done in Mr. Tiwari's case, my lord. I will put it and I'll give it by day after tomorrow, my lord. Your lordship may keep it for filing notes, my lord. That's very
keep
clear.
a final argument day after tomorrow. You complete whatever. We'll give you each 15 minutes.
All right. Day after tomorrow, my lord.
Right, because I feel like I'm running around circles also. But if
Yes,
you go,
I
you take us back again to 92, 93, then we go back to quorum, then we go back to the SC Act, then we go back to enabling. It's
I'll put one note, my lord. I'll put one note.
yes. At least for further thing after tomorrow is.
I request for Thursday, will it be possible, Thursday?
Yes, okay,
If it's
fine.
possible.
Thursday, yes. Place the matter on
Thursday.
Thursday for further hearing. Parties are permitted to put in their respective notes on submissions. Yes. Otherwise, sorry. I mean, I want to conclude the matter, but then it has been dragged on in such a manner that
We have not made your lordship's life any easier, in this matter. So we will one page, additional page, I will add to my submission.
Right. That's the only thing. Yes. Thank you. Yes.
Obliged.
Kan kami na yung lipan. Katuloy pa kamdan lang ba na
Item 25.
Please, Lordship.
Yes.
Lordship, as per the instruction of client, they have received their monthly pension only till the month of August of 2024, my lord.
24?
Yes. Another 6 months left.
But they got the money this time. How much money has government given you?
We have paid them till August, Your Lordship, 24.
No, how much money you got now? Is there any money being set aside to...
That was the money that we received. That was
already
paid to-
spent?
Already paid to them, Your Lordship.
No, just it's.
When did you receive your pension last?
I think last month. my lord.
Okay. The money given by the states only been used.
That money was used for.
So far as pensioner is concerned, my lord, as per the RTI that we have filed, monthly the district council is required to pay 50 lakhs per month. So I don't know how much money they have got recently.
No, that's not privy to us, or rather we can't ask them to. They have other expenses also.
The problem now, the pensioners are dying, my lord. The last occasion also 2 pensioners died, and we have brought to the notice of this honorable court. So it's a very sad state of affairs, my lord. It's causing them great difficulty in maintaining their day-to-day life, my lord. And we are not asking for other pensionary benefits, my lord, like gratuity or leave
We
encashment.
understand.
We're just asking for
We
maintenance.
understand that.
Yes, my lord. If no effective order is passed from this honorable court, perhaps
Effective orders already passed since 23.
we are grateful for that, my lord. But
we see, the thing is that repeated orders have been asked for to disburse their salaries, pension, and all. Why don't they do a clean-up act of their own council? Then
And
you
recently,
examine the golden handshake scheme, or the deadwood, you just
That,
retrench them, or you do away with them.
that resolution has been taken.
Then, unless there's some efficiency in the how
because
you
the
run.
problem right now, my lord, is that the only plea that the district council is taking is that the funds that they are entitled from the state government, they are yet to receive. But there's no concrete step
They
that's
have
been
no
taken
other
by
source of
them.
revenue also.
Some
What concrete
initiative should
steps
be
will
taken,
take?
my lord. Some initiative should be taken to.
See, some orders that can be complied with, some orders which they find difficulty. You repeat August 24, but then you don't anymore take instructions to what month you give them, at least till.
So far, we could only pay them till August, Lord. Otherwise, we are willing to.
How many months in one tranche did you get the amount? How many months did you get the pension?
Lord, my lord, I'll have to take instruction.
No, I mean, in this time they got last month. How
Around
many months?
2-3 months, my lord.
Or more than that?
No, around 2-3 months, my lord.
So if you got a substantial amount, it should
Because
be
what has-
there to at least
because what has
sustain you
happened
for a few more.
because what has happened, my lord, the money, it seems that they have dispersed it for salary as well as pension, my lord. And salary, I think it comes to around 7 crore plus, my lord.
A month.
A month.
Yeah, you get it all a deadwood. Otherwise, it become redundant. Janti Hills and Karu Hills, same problem. Don't have the problem Kasi Hills.
Yes, my lord.
Are judicial officers being paid?
My lord,
They're being paid also.
I think there's a problem in that end also, my lord.
Is that correct?
We'll see. They have been paid, Lord. But what
In
is
the judicial
backlog?
department, my lord.
No, because last time this court has expressed that if they're not being paid and and if those courts can't function, then we have to make a separate budget provision, which is
Yes, my lord. Because they're
non-negotiable
They have been paid,
with regard to the.
to which months? I'll have to take.
Because everyone is in the same footing, my lord. So far as the staff of the
No,
judicial
we've got
department,
reports
sir.
that because the case not progressing, because process servers are not being
Yes,
paid
yes.
the salaries.
That's also one big
We
problem.
can't have the poor people suffer because of that.
There's a crisis, my lord. I don't know how will they address
The government
this.
will have to pass an order like the taking of primary education.
Exactly, my lord.
It'll be good also. They'll be absorbed into the proper judicial cadre. Then
Exactly.
they'll have scope for promotion.
This area needs to be addressed also, my lord.
You should do something about it as responsible advocates from that area.
Yes, my lord. We'll think of doing something, my lord. Perhaps approach this honorable court again specifically on that issue.
Otherwise, they have to be absorbed. Otherwise, what will happen to them? That is the judicial part. What's happened in those primary schools that even the staff, are taken to be regular government employees.
Yes,
that kind of thing. And so once that's done, there's no issues.
Yes, my lord.
It is reported by Mr. Jeshila, the council petitioner, that the petitioners, how many in number? 73.
Yes, my lord. 2 of them have expired, so
yes,
they have been struck off, my lord.
the petitioners have been paid their pensions till August 2024. Stop. Next paragraph, have been paid till recently. Stop. Next paragraph, Mr. M. L. Nongpure appearing for the respondent to 4 submitted to the extreme financial
Constraints.
crisis or constraints. Constraint. Even the amount received recently has enough. We learned that those constraints, efforts are being made to disburse the pension of the petitioners in a timely manner. It's directed to come back to such every 3 weeks. Come with instructions. How are we going to address it? Yes. So we're keeping this case alive only.
Yes,
you won't get a pension anymore.
Then next matter is relating to the contempt filed by the staff, my lord.
Just together, next week. Putting them in jail won't take out his,
I
won't get a
understand.
pension.
29.
Yes, Mr. Jha.
Hamid, please, Your Lordship. Your Lordship, I pray for accommodation in this matter, Your Lordship.
Why you not got instructions on the additional affidavit? What is his disability?
No, it is with regards to incompetency of the person who has punished the petitioner.
Oh, yes. What to do, MS Mirchan?
I pray that the matter will come up after 1 week, Your Lordship.
Where's Dr. Mozika?
He's on legs, Your Lordship, before division bench.
Is submitted by MS so-and-so on behalf of the instructions will await it on the additional affidavit filed by the petitioner. List after 1 week is expected that by next week the instructions should be available with the council. Yes.
30.
May I please, Lordship? My Lord, I am not getting my salary for the past 2 years from the month of April 2023. Being aggrieved, I have filed this petition before this Honorable Court. My Lord,
Mr. Pubin, he's on leg before.
2 years have not got. Any
no.
other connected petition? This one?
No, my Lord.
Sure.
My Lord, so far I am concerned, I am not aware.
You have the file with you?
We have already filed our affidavit.
So you have the file with you now?
Yes.
Because they have said that there was a petition, but there is nothing, Your Lordship, to my knowledge. They have not enclosed anything, any case number, nothing they have enclosed. They have not mentioned. But Your Lordship, in the affidavit there is a whisper, in the affidavit in one document there is a whisper that there was some case. I will just point out, Your Lordship.
Where is one number 5?
Yes, my Lord. My Lord, I was appointed.
Let's see where they make a statement.
My Lord, in the affidavit of respondent number 5.
Yes. That's why this court asking all these cases when non-payment salary is also under teachers appointed their place or your illegally appointed teacher, that is why you're not entitled to salary.
Yes, my Lord, but here they have not annexure 1, my Lord, page number 7 of the affidavit.
Annexure 1.
Yes, my Lord. Here, my Lord, they have referred that the undersigned hereby revoked that teachers approved order such and such.
You have not got the number of this.
No, my Lord.
Of this division bench matter.
No, my Lord. They have not even stated in the affidavit also. Neither the state government, neither the respondent number 5.
State government.
State government. The state also they have not mentioned, Your Lordship, regarding any writ petition connected with this particular.
That's why we revoked teachers approved order so and so. So that means your approval was revoked in 2018.
My Lord, they are saying, but the state government they have filed.
It was approved in 2018.
Yes.
But it was revoked in.
Again 2018. They have enclosed this document, my Lord, respondent number 5. But I have not received any such revocation order or any notice of providing opportunity of being heard, anything to my knowledge. Suddenly, before this Honorable Court, they have enclosed this document. And even the state respondent, my Lord, they have not said. In fact, the state respondent, they have said that there is no record for my appointment. And
yes, MS Lalu. The other one, sorry. Yes. Any records in the government file regarding the other matter? Mr. Yubin, you've annexed one annexure in your affidavit,
my Lord,
saying that the orders, the teachers approved under such order have been revoked. Which represents that?
My Lord,
page what page?
7 of the affidavit.
It's 7 the affidavit. Yes.
This is the, my Lord, as per instruction, this was wrongly approved.
No, fine. Where's the case number? Let's see that order.
Yes, ma'am.
Which one?
Whether this case pending or not. See, you just annex that, do you?
Oh, yes, my Lord.
It's sub judice. Then?
Oh, yes, my Lord. That order, order is writ appeal number 11 of 2018, my Lord. This is disposed of, my Lord.
You aware of this?
No, my lord. I'm not party. I'm not aware because I tried to find out also, but
No, it is here. This is the one. In fact, I think we have placed on the record also one.
No, there is no. I have not got
in a
anything.
course record. If I've not made, I think we have placed one, or if not, my lord. We have. Then we'll place this.
In the course of hearing of the instant matter, Mr. S. Pandit has referred to Annexure 1 of the affidavit filed by Respondent 5 and has submitted that though it has been indicated in the said annexure that a matter which also concerns the writ petitioner herein is sub judice before the court, no further details have been given said affidavit. Stop. Anyway, Ms. P. U. Win, counsel for respondent number 5 has today submitted that the said matter was writ appeal number
WA number 11 of 2018.
Of 2018 between?
This is between Mojail Hawk Mundal versus State of Meghalaya.
I'm not the
So,
party.
so
what did it say the order?
It is a post, my lord, because there's only.
Then you give him a copy. Let him find out.
This I'll give you later.
Was this writ a party there?
No. There was not a party here, my lord.
What's the connection with this case? And
No, my lord, here, my lord, since a SSS school teacher, my lord, there can be only one sanctioned teacher for science and mathematics, one for social studies, and one for language, my lord. So this Mojail Haik, my lord, he by wrongly, my lord, his name was not approved earlier, my lord, even though he was selected.
The same school where she's teaching?
Yes. So that post, my lord, by this order confirmed that it belongs to Mojail Haik. So now that cannot.
That has a cascading effect on him.
I am social studies. I am teacher of social studies, but I do not know.
Social studies. Okay. Yes, you see what happened. You come to para 4 of your petition, Mr. Pandit.
Yes, ma'am.
You are approved by this order 22/10/2018, correct?
Yes, my lord.
So what happened was that this order has been revoked by this annexure 1.
Yes. No, that they are saying, my lord.
No, it's the same order.
Yes,
See,
yes, yes.
you were approved by competent authority, by approved in the contained memo number.
Yes.
Same thing, SSAWH, MISC, so on, 2018, up to 1/3/2010. Now, this annexure 1 is not under challenge by you.
Yes. My lord, this is not in my knowledge. Further, your lordship will see that there are 3 teachers whose appointment has been revoked.
Doesn't matter. But what you concerned with?
My lord, then I'll take your lordship to the affidavit of the state government. My lord, that is they are producing now, your lordship. There is a resolution and the approval by the government. I'll just take your lordship.
Where's the resolution? Where is the other letter?
After
then
this,
whereby
after this, your
this
lordship.
letter has been
After this letter, revocation.
Has been disregarded again.
My lord, I'll
This,
just take your
this
lordship.
29 November 2018. What's happened to this letter?
I do not know your lordship, but this is, I'll just take your lordship to the affidavit of this state government.
No. What this court wants to know is 29 November 2018, whereby approval has been revoked, whether it's been restored or whether it stands revoked.
My lord, they are saying that in this.
Not they are saying, according to you, whether this stands revoked. First, your approval was. What happened was, it has been revoked. Correct.
Yes.
So revoked means you're not approved. You're not a sanctioned teacher. Yes. Correct. That's where you stand. Yes. Now they have annexed. This is what it comes in next year, right? Now you claim your salary for the period that you've taught, whatever. Yes. Now, whether there's no denying that you approve by a certain approval on 22nd,
yes.
That is revoked. Yes. Whether that this revocation, yes. Dated 29 November, has been revoked again or whether it still stands?
No, my lord, this letter they have produced, but they
still stands or not?
Because this is not your lordship. This is not. I think this document where they have produced your lordship. Where from it has come also. The state government also they have not approved this type of letter.
Yeah, Sarana, what do you say about this? It's been revoked.
Lordship, as per my presumptions, Lordship, which I've kept an affidavit, Lordship, we didn't even issue such order, Lordship, the approval order.
They are saying approval order also was not approved.
Then?
They are saying,
That's
your lordship. Yes, your lordship. That's why I am taking your lordship to the affidavit. Paragraph number, your lordship, 6. First affidavit, your lordship, of the state government. They are denying even the approval order. Initial approval order.
So fine, they've denied it and they've
no, but that is contrary to the document annexed by them. This document is.
On what basis are you claiming salary then?
My lord,
are you still teaching?
Yes, your lordship.
How is that possible then?
My lord, they are not denying that I am not teacher, your lordship.
The entire case.
They are not denying.
That means they're managing
and
to
I will take your lordship.
Teacher,
my salary also they have credited in my account, your lordship. That is there till March 2023.
That is the point, my lord. When we have made a mistake in the, because all these names more or less little bit
my
similar.
Lord, first I will take your lordship to this statement.
We made a mistake that we are admitting. We made a mistake in forwarding her name where her name was not supposed to be forwarded, my lord. Now, just because we made a mistake and some credit,
that was not a mistake.
I like the excuse.
Yes, that was not a mistake, your lordship. That's why I am taking your lordship to the.
You're not a sanctioned teacher. Show your approval.
Yes.
After the revocation, show that approval which you say you approve has been revoked and you're an approved teacher by the competent authority.
My lord,
that's the only thing.
Yes.
If you stand that footing that fine, I'm a sanctioned teacher, social studies or language or whatever, I was appointed, okay, might be in the midway it was revoked for some other reason, because of other case, then another person was confirmed a sanctioned teacher. After that, then my approval has been revived and I'm standing to get my salary, yes. Now you're paying salary like two wrongs will make a right.
No,
then
my lord, it is not salary by mistake. I will take your lordship to the statement. And thereafter, your lordship, I will.
Who's affidavit?
State government.
Where? Where have you said it?
Page number 3, your lordship, paragraph number 6.
Yes.
That in reply to the amendments made in paragraph number 8 of the instant writ petition, it is denied that the name of petitioner appears in the official record of respondent, and it is further denied that the payment, if were made to the petitioner by state respondents. It is further denied that the petitioner is a sanctioned teacher.
Yes.
Appointed by the state respondent, since the respondent number 5 has initially credited salary of the petitioner into her account by the resolution dated 27/4/2019. I'll take your lordship to the resolution.
Let's see the resolution.
Yes.
Where is that? Next one.
Yes.
Yes.
This is the type copy, your lordship, page number 9.
Yes.
Your lordship, they have typed, but certain words they have said that it is illegible. I have typed, your lordship.
See, all well and good, but where's the approval?
No, my lord, it will be clear from this resolution only.
Yes.
My lord,
number
2. Be it resolved in the meeting today that the SMC of the Matri Mangal Girls SSA UP school has been facing so many discrepancies in the list of sanctioned teachers, since almost all the teachers are running after sanctioning their own post, and several fictitious orders were made by the office from time to time varying the seniority norms. The House, after threadbare discussion on the circumstances, finally decided
to identify all the 3 sanctioned teachers of Matri Mangal Girls SSA UP school as per seniority basis wide resolution number 3 dated 28 12
So where's
1998.
the approval, Mr. Pandit?
My lord, approval is there, your lordship. I have enclosed.
Where's the approval?
Enclosed in my writ petition.
18 approval?
Yes.
No, that's been revoked.
No, but only they have produced, your lordship. Anytime I can also produce, then it doesn't mean that your
That's
lordship.
revoked because of that matter, and that matter that's been decided
No,
from the
and
same
thereafter,
school.
your lordship, just this one. This is and all subject allocated for the sanctioned teacher as follows. These are the point.
No.
Yes.
There's no quarrel with that. Fine.
Yes.
What happened was that it was revoked. Then there was a big halagula in your school. So finally, they had a meeting. Say they should be 3 sanctioned teachers. What happened after that?
After that, your lordship, then this resolution number 3, your lordship.
What happened after that?
After that, your lordship, this resolution was passed. The state government, they have the record and they have credited the salary in my account, not by mistake.
So what happened? Where's the approval?
Approval is that one only, your lordship, 2018. They are saying that it is revoked. Suddenly they will bring anytime. Again, I will bring, your lordship, that this is the.
How do you bring?
No, but this is the document, your lordship. This is not recognized by the state government also. In their affidavit, they in fact they are saying that I have not been approved.
That's a stand, and it stands to reason also. You enclose your approvals. The only approval order you have is 22/10/2018. Correct?
Yes.
Fine. Now that annexure they've annexed is that this annexure 1 is that this has been revoked.
Yes.
Finish.
Yes. My lord.
Until further orders.
Yes. Until further
this
orders.
was 18, and that this management company is 2024.
Yes.
So is this already
2019? This is 2019.
This resolution 2019.
2019. Yes, lord. Sir.
Now same management committee is still there.
That is the thing, your lordship. So, what they anytime they can bring any document, your lordship.
See, the score's not to go into a roving inquiry who can bring a document. We are going what material is produced for us. Now there's a document produced by a state of the competent authority saying it's been revoked. Unless you show an order that the revocation has been set aside and you might get a salary from God knows wherever for a source. No, but unless you can show that the revocation has been set aside and as per the resolution of 2019, you are a sanctioned teacher, then you can't pray for your whatever relief you're praying for.
Now, my lord, if this document is genuine, this revocation order.
You're not going to genuine or ungenuine.
But that revocation was in respect of all the 3 teachers, and this affidavit is filed by that revoked teacher also. It is included there. This particular affidavit has been filed by the teacher whose service has also been revoked, whose appointment has also been revoked. In that letter only.
So maybe they've been approved separately.
So where is that, your lordship? They have not produced.
You asking the court to go to that?
But they have to produce, your lordship, any document which shows that after revocation.
Get some instructions or something. Get some more materials. Stop in the course of hearing. Yes. No, Godwin has since been decided, wherein a teacher in the said school has been confirmed as a sanctioned teacher.
Yes.
Stop. Next, it is noted in instant matter that the writ petitioner claims to be a sanctioned teacher, and to this effect has placed heavy reliance on a resolution of the managing committee arrived at on 27/4/2019. Stop. The only approval order from the competent authority that has been annexed, however, is the order dated 22/10/2018 and closed annexure 6 to the petition. And as observed earlier, has been revoked by annexure 1 letter dated 29/11/2018 of the respondent number 5. Stop. Next one, this court is in a quandary as to QNDRY, as to the exact situation and position of the case, and this, especially with regard to the current status of the writ petitioner. However, for the ends of justice, responsive permit is allowed to seek more instructions, especially with regard to whether there is any subsequent approval of her appointment in the school of respondent number 5. This is up to 3 weeks. Otherwise you have no case. You're just prolonging it.
All right.
We go on materials. We're not going to go on fact finding.
35.
Yes. Yes.
Please, Your Lordship. Your Lordship, I pray for accommodation in this matter as well, Your Lordship.
At second half, where's Mr. Dr. Motika?
He's still on legs, Your Lordship, before the division bench.
After some time? What's the matter about disability?
The digital.
This is about
okay.
disability. I was
Yes. After, yes, because the council is available after some time, yes.
36.
May I please, Your Lordship? Your Lordship, I've come before Your Lordship with a limited prayer, Your Lordship. That's for the state government to consider my...
What's the name, Rebel or Yobel?
Riobel. To consider my representation for appointment, Your Lordship. Your Lordship, the DSC had issued a advertisement dated 1/11/2012 inviting applicants for the post of sericulture demonstrator, Your Lordship. And
Select list alive? When was the last select list generated?
it was in the year 2014, Your Lordship.
Select list 2014?
Yes, Lordship. There was a long litigation which was pending before, which was filed by some of the candidates, Your Lordship, before this Honorable Court for appointment.
You're overage now.
Yes, Lordship, she's overage now.
Then?
Lordship, I've only come for a limited my limited prayer is just for consideration of my appointment, Your Lordship, my representation. Lordship, what happened in this matter was that some candidates I was selected, Your Lordship, in this exam. I was ranked 13.
Where's select list?
Select list is at page 23, Your Lordship. The type copy is at page 24. Here I'm ranked at serial 13, Your Lordship.
Okay. This is from the District Selection Committee.
Yes, Lordship.
Yeah.
And the District Selection Committee had recommended candidates 1 to 12 for appointment.
1 to 12, you were left out?
Yes, Your Lordship, I was left out. However, no appointment orders were made, Your Lordship. So the candidates who stood at serial number 2, 7, 10 and 11 had filed a petition before this Honorable Court, Your Lordship, for none.
Are they working now?
Yes, Your Lordship. They were only appointed in the year 2022, Your Lordship.
From the same select list?
Yes, Lordship, from the same select list. And here in Lordship, the candidate who was ranked at 12, Your Lordship, from the select list was not a party to the proceedings, Your Lordship. And however, even this person was appointed, Your Lordship.
Number 12 is whom?
Yes, Lordship. Number 12. I filed my representations, Your Lordship, before the official authorities. However, my representations have never been considered, Your Lordship. Yes, Lordship. I had filed it first on 2014, Your Lordship. My representations are page 40, action 9. I had filed 3 representations. However, none of my representations were considered.
Where's representation? Let's see.
That's at page 40, Your Lordship. My first representation was filed on 22nd April 2020. 2022, Your Lordship.
2 days, Mr. Lasanglia.
Yes, Lordship. I have my only limited praise for them to consider my representation,
Yes, Mr.
Lordship.
Moomin.
Please, Your Lordship. I have few points to object, Mala. The first point is that this result is valid only for 1 year.
Yes.
They should have come to the
court before that.
Within 1 year. 2014 is the result.
So these other people came within 1 year.
Within 1 year, Lordship.
Yes, he didn't come.
No, Your Lordship.
What to do then?
Just let my representation be considered, Your Lordship.
How would they consider it?
Because, Your
Nothing to
Lordship, here,
consider.
what has happened here is, even though the person ranked 12th from the select list was not a party to the writ petitions or the writ appeals, this person has been granted appointment, Your Lordship. Pending the disposal of the writ appeals, which was filed by some of the candidates, their appointment had been the respondents had decided to appoint the petitioners and the person ranked 12th from the select list, which is after 8 years, Your Lordship, after the select was.
You mean which person was not there, was not a petitioner? Which one? From your list at page 24.
Number 12, Your Lordship.
Tiful Suna.
Yes, Your Lordship.
You can't one aberration can't vest you any right.
Oh yeah, that person's name is already been recommended in the year 2014 itself by the DSC to the district secretary.
See, your senior thrown you to the deep end of the pool, huh? You pass adverse orders, you take fine. Otherwise, I don't think that will any relief. Even for consideration or representation, also use a dead letter. There's no point. You prepare, get some judgments.
Yes, Lordship.
Yeah.
Oblige, Your Lordship.
Second call 35.
Yes, where's the yes. Yes, MSO. Where is submitting from Delhi?
Yes, Your Honor.
Okay, yes.
Please, Your Lordship, I am prepared. Please, Your Lordship, this is item 29.
Item?
35. 29.
35.
35, Your Lordship.
Yes, yes. Please start. How long you'll take?
Please, Your Lordship, this is the case. Please, Your Lordship, I'll take about 10 minutes.
Or if you can take second half, Mr. Dr. Mozika will complete it. Or you can start, yes. We'll have to.
It's a short matter.
Yes. Try to finish in 5 minutes, yes. Yes.
Please, Your Lordship, this is the case where I had applied for the post of warrant officer, personal assistant for the state of Chhattisgarh in Assam rankings.
Okay.
Please, Your Lordship, and I was declared disqualified for the same on the ground of digital tremors.
Okay.
I'm sorry, essential tremors. If Your Lordship would have that RND, that's at page
Page?
31.
Yes.
Please, Your Lordship, you see that there actually adherence to unfit on account of essential tremors.
Yes.
And this was conducted on 15th of July 2023.
Yes.
Please, Your Lordship, immediately thereafter, I got myself examined from AE's rifle.
Yes.
And Your Lordship would find those documents at the next page over, page 32.
Yes.
Please, Your Lordship, see that I got myself examined from 1st August 2023. And Your Lordship would find the relevant After the detailed examination, Ames Raipur found nothing wrong with me. Please, in your lordship,
Where's that?
found. Yes, your lordship, which is. Your lordship would find the final at page 38A. Patient is medically fit for recruitment to army.
Okay.
And then you know, just one more point. In fact, under their own guidelines, your lordship would find their guidelines. Not all kinds of tremors are unacceptable. Your lordship would have page 52.
Yes.
Please, your lordship would see seriatim 7. These are minor acceptable defects. Acceptance of candidates suffering from shriveling defects, candidates presenting with mild degree of the following defects may be accepted as specified in the relevant paras. And your lordship would have a P.
Yes.
Only tremors without any organic cause.
Okay. Yes. Yes.
And if your lordship, just last point, if your lordship would have the guidelines for tremor, they had to send me to a neurologist.
Yes.
So lordship would have page 57.
Yes.
Please, your lordship, see, these are the guidelines for how to be conducting review medical examinations. Your lordship would have paragraph seriatim D.
B.
D. Review medical board may obtain opinion of concerned.
Where are you reading from? Oh, D. Okay, patient. Okay.
Review medical board may obtain opinion of concerned specialist or super specialist of government medical college and hospital in case of any doubt. Therefore, in cases of rejection in review medical examination, clinical findings should be corroborated with confirmatory tests, investigations, opinion of specialist, super specialist of government hospital, medical colleges, government approved private medical centers, whichever and wherever applicable. Following examples are cited for the guidance of review medical board. So your lordship would straight away come to G under this. Any tremor in hands or other parts of body, curiosities should be ruled out and neurologist opinion should be taken. Please, Roshi, none of this was done. So, number one, they have not even specified whether my tremor was a minor defect for which I could have been admitted. And number two, they have not even taken an opinion of any neurologist, which was essential to be taken in this case. So, today, all that I am saying is that they can re-examine me from all these angles and then give a final opinion as to whether I am fit or unfit.
Yes.
Especially in the light of Ames report, which is conducted only after within a period of 15 days of the medical examination conducted by them and has rendered me fit for recruitment.
Yes, Dr. Mosika, why you not sent for review as per your guidelines itself, revised uniform guidelines?
Well, what appears from the affidavit, my lord, the radio diagnosis was done, my lord, at page 22 if we next.
Oh, the affidavit?
Yes, my lord.
Page 22. Yes. Done by whom?
This from page 22, 23, Giant Hospital, only for this investigation purpose, my lord.
You sent him there?
My lord.
So?
And moreover, my lord, there are concurrent findings of the first medical examination and review medical examination of the same ailment, my lord. My lord, I placed on last two pages also two documents. Was it sorted? I submitted the last email.
Yes, the apex diagnostic.
It's a medical booklet.
Yes, right.
Yes, well. But on this, if Lordship sees,
Where disturbance from?
it's marked in the reverse order, my lord. Page 21, 22, 23. Page 24, Lordship kindly says, my lord. This is the first medical examination. And on the next page, the Lordship will see.
Just mark it in the correct order. See, one thing is that they had done that examination where he found that the tremors were there, but then in August itself, before EM, they said no tremors. At that point of time, you should have sent it to that review medical board.
Review is done, my lord. That's what I'm trying to place, my lord. There's a two-stage process, my lord. There's no provision for no second appeal there, my lord.
No second appeal.
My lord.
Yes. Yes.
On page 7.
But the license was never associated with that review medical examination.
Who was
And if you
associated?
also see the papers that
Let me just point out first.
Yes.
Page 7, Your Lordship. This is the first medical examination.
You need to file affidavit on this one. I think last time we got express. If we're going to take cognizance of this, he has to come an affidavit. We can't pass orders just on papers handed over.
I can do that one.
Why didn't come the first affidavit?
But this is not a disputed.
At cell number 13, locomotion system, digital tremors, condition of spine. What is this? What can't see? We read the writing also. What does it mean?
Well, only at page 8, my lord, at serial number 27, I wanted to point out, my lord.
Yes.
At serial number 27, unfit on account of digital tremors. Then against this order, my lord, they preferred an appeal or review. Now, review report is at page 2, my lord.
Yes, it's a tremor again. You kindly file your affidavit. If this is going to settle the whole case, yes, in the course of hearing, Dr. Mosikia has produced certain medical certificates indicating the fact that a review had been done with regard to medical condition with the petitioner. We directed to put the same affidavit as the same is crucial for the matter. Yes. Just after 2 weeks. Put it on the affidavit, then we'll dispose it off.
38.
Great.
You've taken a second half,
Yes,
Mr.
yes, sure. Thank you, madam.
Mr. Pandey, second half, yes. 2 o'clock.
Yes,
Wait a minute. Yes. Yes.
May I start? May I start, my lord?
Yes, yes, please.
My lord, petitioner is engaged in providing dark fiber infrastructure solutions for telecom sector. Respondent number 2, MEPTCL, floated tender next year 3, page 61.
361.
Page 61.
61. Okay, 3.
Page 61, annexure 3.
What is this? OPGW.
To select exclusive operating agency for operation of optical ground wire, OPGW, for the state. Its clause 3.25.1 at page 77 says that MEPTCL will award contract to successful bidder. I want to read out, my lord, clause 3.25.1. The MEPTCL will award, page 77, my lord.
Yes, yes.
Will award contract to the successful bidder whose bid has been determined to be responsive and has been determined as the highest evaluated bid, complying with the criteria as set out under the RFP tender. The MEPTCL evaluation of bidders and decision to award shall be the final. The MEPTCL shall be the sole judge in this regard. In case the required price to award the contract is not viable, then MEPTCL may explore auction methods for realization of floor price. Right, my lord? This further clause 3.25.3b.
Yes.
Is on the page 77 says that notification of award will constitute formation of contract. This is very important, my lord. Further clause 3.25.b of tender document, this page on the same page, clause 3.25.2 speaks about that MEPTCL reserves its right to accept or reject any bid prior to award of contract without thereby incurring any liability to the bidder. My lord, I would like to emphasize on the word prior to issuance of letter of award.
Yes.
Not thereafter.
Yes.
Petitioner being highest bidder, letter of award, annexure 4, my lord, at page 150, was issued in its favor. It is dated 29th November 2023. Its clause 2.1.
Once just go a little bit slowly.
Sorry, my lord. Sorry.
From,
page 150, my lord.
Yes. Yes.
Letter of, it is dated, my lord, 9th November 23.
Yes.
Its clause, my lord, 2.1.
Yes.
Speaks about confirmation and acceptance of bid of the petitioner. I would like to read it out, my lord.
Yes.
We confirm having accepted the bid of Messrs. Sterlite Interlinks Limited, referred to at para 1.3 above, read in confirmation with specifications, terms, and conditions of the bidding documents referred to at para 1.2 above, and award on the bidder a contract. They are using the word contract. Hereinafter referred to as the contract, my lord, again in bracket, for monetization of OPGW assets of Meghalaya Power Transmission Corporation Limited, as per this letter of award. Right, my lord? Further, its clause, my lord, 5.1 at next page, 151.
Yes.
Says that this letter of award shall constitute formation of contract, notwithstanding anything stated anywhere in the bidding document. This LO will constitute the formation of contract.
Okay.
My lord. Therefore, my lord, letter of award annexure 4 and tender document annexure 3 both speak
now
that.
See 5.2.
May I read it? 5.2.
Here at 5.1, okay, LOA will consider formation of the contract.
You shall
And
enter the
5.2,
formal
you shall enter a formal
contract agreement and within 15 days, my lord. This contract agreement paper was to be supplied by the agency itself, MEPTCL. But we provided them.
Okay then.
Therefore, my lord, again, for the sake of repetition, letter of award annexure 4 and tender document annexure 3 both speak that letter of award or notification of award shall constitute formation of contract.
Yes.
Right, my lord? While letter dated 5th December 23, annexure 6, my lord, at page 154, respondent MEPTCL requested to take up the matter with XEN, executive engineer, for a joint inspection.
Okay.
Which was finally done. I mean to say, my lord, in furtherance to this letter of award.
Yeah, all formalities were completed.
They are. Next, my lord, since infrastructure assets management agreement was to be executed within 15 days, I am coming to that clause which you were, my lord, were referring. Latest by 10th December 23. So the petitioner shared a draft agreement to respondent in time. Though as per the tender documents, entire process of providing agreement was the responsibility of MEPTCL. Whereupon respondent number 2 unilaterally asked petitioner to replace clause 5.1e of the agreement dated 8 January 24, whereupon petitioner submitted fresh agreement, my lord. On 8th.
Where are you reading from?
I'm just telling that 156, my lord. One page with reference to above, I am directed to enclose here with a copy of letter of MEPTCL for chairman cum managing director. In this regard, and in the line with the decision of Board of Directors dated 17th November 23, while Resolution 6, it is requested that clause 5.1.e of the infrastructure assets management agreement may kindly be replaced with Messrs. Sterlite Interlinks Limited shall be responsible for the maintenance of all optical fiber assets of the corporation, including those remaining optical fibers which are used by the MEPTCL or any third party authorized by MEPTCL in accordance with best practices and relevant rules and regulations of CEA, CERC and DROT. Right, my lord? On the same day, my lord, at page 155, respondent number 2 wrote another letter to us. It is hereby, last line, my lord, of this. It is hereby directed that the agreement shall not be executed, kept in abeyance till further orders. Because this condition was imposed that you replace clause 5.2.11e, unless and until you replace it, that this letter of award is kept in abeyance.
Right.
So, my lord, we agreed to it and submitted a fresh agreement on 8th December 24.
8 December 24?
8 February. 8 February.
That is page?
Page, I am giving you. I am just referring to one. February, 8 January. Hmm? 8 January, it is 8. My lord, sorry, it is 8 January. Page 168, Annexure 2.
Annexure 11.
Annexure 11, sorry. 11. Submission of consent for proposed amendment in infrastructure set management agreement by letter with reference to Itna dated 11th December 23. Attached herewith. We are in receipt of letter number Itna. We do acknowledge your consent to accordingly amend the clause in IMA. We agreed hereby.
Yes.
Thereafter, sorry, my lord, this page for wrong page numbering.
Yes.
I have quoted wrong page. Sorry for it.
No.
Yes, sir.
No, it's right. 168. Yes.
8 January. Okay. Right.
It's right.
Thereafter, my lord, yes, Petitioner were now submitted fresh agreement on 8 this February.
Okay.
Accepting the above condition imposed by respondent number 2. Thereafter, my lord, a joint meeting of the petitioner and respondent held on 14th March 24, asking the petitioner to share revenue sharing process which was shared.
Where is that?
ये दिखाना भाई ये निकाल के रखने थे आपके पास नहीं आपकी कोशिश Page 169, my lord, annexure 12. यही है ना?
This is mail copy. We send a hard copy also.
Okay. At the outset, my lord, with reference to meeting held on dated 15th March 24 at MEPTGL Secretariat Office in Shillong. At the outset, I would like to thank you for your time at your office to discuss our proposal on OPGW monetization of MEPTCL network. As discussed with you in the meeting at your good offices, please find and enclose the financial working sheet which provides a rationale on why it's beneficial in the long run to engage Sterlite Power as the operating partner for OPGW assets monetization under the jurisdiction of MEPTCL for your kind perusal. On long term, it is also very important for your good office to know the direct as well as indirect benefits to be passed on it to the utility through the operating partner model. Right, my lord? Thereafter, my lord, without communicating any correspondence, without issuing any notice, on 3rd April 24, respondent to cancelled our letter of award.
On 3rd of April, where is that?
3rd of April, my lord. Annexure 4, page 60, my lord.
Annexure 2, sir. Annexure 2.
Annexure 2, page? Page 60.
Page 60.
Page 60, my lord. My lord, have you taken out, my lord? 60, page 60. Cancellation of letter of award for tender for selecting the exclusive operating partner.
Yes.
With reference to the above, this is to convey the decision of the board of directors. MEPTCL for my lord, I will also draw your attention towards board of directors meeting in which it was decided to cancel the contract. There is nothing sort of to show any reason that why it was cancelled. Directors admit for cancellation of this letter of award as per resolution number 3 dated 13th March 24 as follows. Resolved that in suppression of earlier resolution number 6 passed by the board of directors in its meeting dated 17th November 23, the board hereby decides to cancel the LO dated 29th November 23 issued to Mr. Sterlite Interlinks Limited bidder for monetization of OPGW asset of the MEPTCL. No notice, eh?
On 15th of March, post cancellation.
Acha, they had called.
They had called that revenue sharing meeting on 14th of March, which you just showed.
After this?
After this.
After this?
March.
Yeah, after this post cancellation, my lord, they again called a meeting.
No, sir. The meeting which we just referred.
Okay.
The revenue sharing model where we shared. That meeting is on 15th of March. And this board meeting is on 13th of March. So post cancellation, they have called us.
So post cancellation, they have called this for a revenue sharing meeting.
Where is that letter?
Yes, I had just shown you, my lord. Again, I am showing it. This, my lord, cancellation letter is at page 60, is dated 3rd April
2024. That page, annexure 12.
Yes, my lord.
Annexure 12. You're referring to annexure 12.
Yes, sir.
Reference meeting, yes.
Yes, my lord. The data different, my lord. This resolution is 3rd March 2004, where it was decided to cancel the contract by the board of meeting.
So after they decided to cancel, they sent
They cancelled. They called post meeting for sharing revenue.
Or showing the revenue percentage and the
Is that the senior submit?
I'm sorry.
So, my lord, the respondent to cancel the letter of award annexed to unilaterally, arbitrarily and illegally after getting from petition about revenue sharing process. Thereafter, my lord, various letters dated 16th May 24, 18th June, 6th August, 27th August were written by petitioner to respondent but no response. As per
No, one
clause...
second, sorry, I didn't get your name here, Mr.
Mr. Jain, Ramendra Jain,
Okay.
R. Jain, my lord, in short.
Yes. No, the thing is that 169, now the cancellation was on 3rd of April 2024, correct?
Yes, yes, my lord.
And this letter, Ratio 12, says, with reference to meetings held on 15/3/24.
15th March.
Yes.
So prior to calling this meeting for revenue sharing process method, on 13th they have called the meeting of board of directors and decided to cancel the contract. This shows their arbitrariness, illegality and unilateral action.
Yes.
2 days earlier they decided to cancel the contract and thereafter they are asking us to call a meeting for sharing the
Proposal.
Discuss,
yes.
Okay.
Yes.
Now, again, I am reading this clause at page 77 clause, which is very relevant, 3.25.2. Respondent number 2 was bound to award a contract to petitioner, which was done as per legal process, and then no authority to cancel petitioner's bid after issuance of letter of award. Further, since a letter of award annexure 4 is a contract document, therefore, after its issuance, it could not have been withdrawn unilaterally. Now, my lord, there were in tender documents there were certain conditions. On what ground a tender could be or bid could be cancelled? These are at page 91 of the tender document, my lord. Para 6, para 6.1 and 7. Termination rights. Page 91, my lord.
Yes.
Termination rights, my lord.
Yes.
In the following events, the dark fiber leased to bidders shall be liable to be disconnected, disabled by MEPTCL, and MEPTCL is the authorized agency to issue disconnection notice. A. The successful bidder transfers its right to any other entity without prior intimation, approval of MEPTCL except allowed assignment. B. The successful bidder sublets MEPTCL's infrastructure asset to any agency, whomsoever without the permission of MEPTCL. Third, the successful bidder damages the MEPTCL system owing to malfunctioning, improper use, non-standard construction of the OFC and connected system of the consumers. The successful bidder uses the leased dark fibers for any illegal and unlawful activity. Rules and regulations implemented by Government of India, Government of Meghalaya, and any regulations from time to time demand so. When the great conditions so warrants. G. The successful bidder has engaged in corrupt or fraudulent practice, my lord. Thus, my lord, there is no such violation from my side. So it could not have been cancelled, my lord.
Yes.
Even in the letter of award, Annexure 2, there is no condition that it can be cancelled or withdrawn without any wrongdoing by the petitioner.
Yes.
Right, my lord. Now, in para number 11 and 60 of affidavit, my lord, page 13, then away. The respondents have admitted page 13, my lord, para 11 and 16. MEPTCL. Have you got the page, my lord?
Para 11.
Para 11, my lord.
Yes.
It is submitted that the letter of award is a notice of acceptance of bid of the petitioner, does not constitute formation of contractual obligation, though they admit that the LO annexure is a notice of acceptance of bid. Similarly, at page in para 16 also they admit that it is the acceptance of bid. However, my lord, mentioning in para 11 that letter of award does not constitute formation of contractual obligation between the parties is factually incorrect in view of clause 5.1, page 51, my lord.
Yes. LOA constitutes formation of contract.
Yes, my lord.
Yes.
Page 51. which says that letter of award shall constitute formation of contract, right, my lord? Notwithstanding anything contained anywhere in bidding documents. My lord, respondents have not produced alleged agenda of any meeting in which viability of contract was discussed by the board of directors of respondent, neither made any correspondence ever, nor ever responded to various letters issued by petitioner. Thus, my lord, respondent could not be put to the petitioner to surprise informing about cancellation of all of a sudden cancellation of letter of award, and therefore giving reference of board meeting without assigning any reason. Till date, no reason has been attributed to us. Now, my lord, the calculation which they have shown in para number 18 of their affidavit are palpably, patently wrong and illegal, hypothetical, whimsical.
What is this? Well, para 18.
Para 18 of affidavit. Yes, yes, my lord. I'm just.
So petitioner on 7 crores and
that it is submitted that decision pertaining to cancelling the letter of ours was taken by the board of directors in MEPTCL in a meeting. I'll go through that resolution in which this cancellation decision has been taken. There is nothing sort of. In a meeting dated 13th March 2024, after considering the financial viability of the project and the various considerations are highlighted herein below, with 100% monetization offset on the existing OPGW route, 641.7 kilometers, revenue accrued to MEPTCL is 1.55 crores per annum as opposed to petitioner's earning of 7 crores. They all are wrong, my lord. All are wrong pleadings. I'll show you. My lord, with a 100% monetization of assets on the existing as well as the upcoming OPGW route of 12.60 kilometers, revenue accruing to MEPTCL is 2.7 crores per annum as opposed to petitioner earning of 9.32 crores. Considering capital expenditure of 54.84 crores by from where they have arrived at this, all these figures, I don't know, my lord. All are hypothetical. 54.81 crores by MEPTCL if petitioner invest on the upcoming 212.60 OPGW route length, break-even period for MEPTCL for recovering the investment in 27 years. Likewise, my lord, all are hypothetical in my point of view. I will show how they are hypothetical and not trustworthy. Right?
Yes.
All are even they are speculative even, my lord. Now, my lord, I want to draw my lord's kind attention towards annexure P1 of counter affidavit, page 45. To be right out of the how the bid of the petitioner was cancelled. This is the main document, my lord. Main plank of their argument and their stand.
Page 45.
Page 45, my lord. My lord, got it?
Yes, yes.
Yes, in the light of the above matter, this is the third, fourth, fifth, sixth line, my lord. In light of the above, the following proposals are placed before the board of directors of MEPTCL for consideration. The board, number one, the board of directors of MEPTCL may perhaps consider expert opinion on the matter of monetization vis-a-vis leasing of fiber pairs. Till that date, I think there was no record, nothing with them. No data was with them, how the figures which they have written in para 18 A, B, C, D. Second, my lord, the board of directors of MEPTCL may perhaps consider legal opinion on the matter of cancellation of LAO to SIL as monetization of OPGW asset is seen to be not favorable to MSC. They were insisting, they were adamant to cancel our contract. The language itself speaks about this. May I read again, my lord? The board of directors of MEPTCL may perhaps consider legal opinion on the matter of cancellation of LAO to SIL as monetization of OPGW asset is seen to be not favorable to MEPTCL interest. May. They are using the word may, hypothetical. Next, my lord, the board of directors of MEPTCL may perhaps Consider leasing of OPGW fiber pairs for which an expression of interest can be sought from prospective telecom players, which may foster competition and ensure commensurate and enhanced returns to MEPTCL. Next, my lord, 4. The Board of Directors of MEPTCL may perhaps consider maintenance of OPGW by the Carrier Communication Subdivision under the System Protection Division of MEPTCL with the system for, my lord, this next I am reading my next para. The chairman sought opinion from Shri L.M. Sangma, Director if the LO, Sangma, Director if the LO to successful bidder can be cancelled after tendering, considering that agreement with the bidder is not executed and that the commercial rates available in market are more beneficial in leasing of APGW assets in comparison to monetization of assets, Shri L.M. Sangma confirms that the LO can be cancelled. Next, my lord, the Director of Finance said that as per the tender document, there is a clause for cancellation of tender at any time by the MEPTCL. The Director Transmission confirms the existence of said clause in the tender document. The Company Secretary informed the Board that the Board in its meeting dated 10th August 2023 has decided that the commercial activities under the telecommunication and network service and other allied services shall be strategic business unit ITNA. The chairman proposed for incorporation of a separate accounting head. My lord, this is the next.
All right, yes.
So this one.
Inviting expression interest from prospective.
So next page, my lord, 46 में second para. Resolved further that board approves the proposal for leasing of OPG fiber pairs through inviting expression of interest from prospective telecom players. So till date, my lord, they have not invited. They have cancelled my.
This is dated.
This is dated, my lord.
19.3.
Ji, my lord. My lord, my contract was cancelled in March 24. Till date, they have not called any expression of interest.
The meeting is the 13th March and the publication of MOM is 19th March.
ठीक है.
The meeting is 13th March.
Meeting is updated 13th March, my lord.
And
Right.
19th March.
This whatever the document is 19th March. Is it a copy of the board proceedings or is it a extract?
It is क्या कौन सा है? 19. It is MOM, my lord.
Minutes of the meeting.
Minutes of meeting.
Not an extract. It's a full.
Yes, it is minutes of.
Extract of the.
My lord. So reply affidavit only talks about board decision of cancellation of LAO. No reason given. May, they're using the word may, will call expression of may cause loss to the MEPTCL. No concrete evidence is there or any data with them.
Yes, Mr. RP General.
My lord, a little bit I want to. Affidavit only talks about board decision of cancellation of LAO but has not shared any document of minutes of meeting to show any agenda to decide above issue as per process of law based on certain facts which was required to be shared with petitioner. My lord, I pose a question to myself now. Suppose in case the petitioner would have cancelled the contract, I would have cancelled the contract. In that eventuality, what would have happened? In that eventuality, my lord, respondent would have penalized the petitioner heavily.
Yes.
Right, my lord? Now I am, my lord, giving you a copy of prepositions which I have prepared for myself and my lord. No.
Letter of cancellation. Letter of what time? 15 days. Bid. I'm sorry.
आपको कॉपी दे दिया ना proposition.
Yes.
My lord, this first proposition is whether tender document was prepared after thoughtful consideration by officers of respondent MEPTCL as the same is running over 90 pages, my lord, page 61 to 152. Every aspect, everything was considered in it. It's a very elaborate tender document. The tender document defines the requirement to be checked for the experience and expertise of the bidders, their financials and relevant experience. Meticulous detailing of each aspect of operation to be carried out by the successful bidder has been detailed in the tender, my lord. Second question, my lord, whether tender document was issued to public at large and to relevant parties as per law. 3 parties have come, my lord, had participated in the bid.
And you were successful?
Yes, I was successful. Yes, the tender document was issued to various entities on payment of prescribed fee. Everyone could buy tender document and participate as per the requirement laid down in the tender document. Third question, my lord, whether the bidding process was followed properly by respondent. Yes, the bids were received as per terms of tender document within prescribed time lines. Number 4, my lord, whether bids were evaluated by competent committee of respondents. Yes, my lord. Committee formed by respondent MAPTCL in this regard evaluated the bid documents as per guidelines laid down in tender documents. My lord, 5th, whether selection of successful bidder was legally correct as per the provisions of the tender document. They are also not denying this fact. The petitioner was declared successful bidder after verification and evaluation of petitioner bid document submitted in response to the tender document. 6th, my lord, whether successful bidder was issued letter of award as per the provisions of tender document. Yes, my lord. Please refer to annexure 4, page 150 to 152 to letter of award, my lord. Whether petitioner as a successful bidder took steps in good faith to comply with the condition of tender after being issued. Yes, my lord. Clause 4.3, page 83, my lord. My lord, I want to show you certain pages, annexure 5, annexure 6, annexure.
No, understood, Mr. Jain.
Okay.
The only ground is that the tender was not cancelled as per the term provision of tender document. There was bereft of any reasons. The decision was taken even subsequently to hold that meet proposal, but board meeting 13th already decided to do away with the tender, and you called for meeting on 15th.
Yes,
That shows that, lack of bona fides of the respondents.
Yes, my lord. So, may I not refer these pages, my lord? Have you understood all right? My lord, now you have decided they have referred a judgment of yours, my lord's judgment, in their reply. This is my lord's. This is my lord. RK India Limited versus State of Meghalaya. RK Limited, it is dated, my lord, 20th August 24. This is your judgment. My lord's judgment.
Who has referred this one?
Encounter, they have mentioned this judgment. In my lord, do you have should I bring certain facts to my lord to refresh my lord's memory?
Yes, sir.
Yes, ma'am. The petition company, on being the successful bidder in a tender floated by respondent number 2 for the work titled East Cargo Hills Circle Distribution System Improvement 33/11 kilowatt substation development, was issued the letter of allotment and a contract agreement was duly executed on 21st December 20 between the respondent number 2 and the petitioner for the said work amounting to rupees 74 crores 34 lakhs 56,822, with the completion time for the said work being 18 months from the defective date of commission. My lord, in this, this petitioner had not completed the work in 18 months. It came before my lords and took the plea that though the tender was floated and allotted to me in December 2020, but money, for the first time, money was disbursed to me in May 21. So 5 months should be added, and there were certain other conditions which were not fulfilled by this respondent number 2. So the work.
What relevance is this judgment?
It is relevant because Subodh Kumar I want to refer to in my sport. You have dealt with this Subodh Kumar judgment in this case.
Okay, where's Subodh Kumar?
Yes, madam. Para 55, my lord. May I read, my lord?
Para 55.
55, my lord. Thereafter, this court in its decision in MP Power Management Company Limited, Jabalpur versus Sky Power Southeast Solar India Private Limited reported in Itna, exhaustively delineated the scope of judicial review of the courts in contractual disputes concerning public authorities. The aforesaid decision is in the following parts.
Yes.
Scope of judicial review in matters pertaining to contractual disputes.
Yes.
My lord, 2 is exercise of writ jurisdiction in disputes at the stage prior to the award of contract. Read out. And 3rd, my lord, exercise of writ jurisdiction after the contract comes into existence.
Where is the reading from?
This is my lord, page 56, para 55 is continuing.
Yes.
Number 1, sir, my lord. Number 2 is the exercise of writ jurisdiction in disputes.
Page 39. Page 39.
Okay.
Exercise of
Yes.
writ jurisdiction in
Yes,
disputes.
right. Yes.
And 3rd stage is, my lord, exercise of writ jurisdiction after the contract comes into existence.
Yes.
Right, my lord? This court held that even after the contract comes into existence, an action may lie by way of a writ to either obviate an arbitrary or unreasonable action on part of the state. Number 2, to call upon it to honor its obligations unless there is a serious or genuine dispute as regards the liability of the state from honoring such obligation. Existence of an alternative remedy or a dispute question of fact may be a ground to not entertain the parties in a writ as long as it is not being used as smokescreen to defeat genuine claims of public law remedy. The relevant observation is under, my lord. After the contract is entered into, there can be a variety of circumstances which may provide a cause of action to a party to the contract with the state to seek relief by filing a writ petition. So, my lord, this whole judgment. Now, my lord, I will like to draw your kind attention towards para 59, my lord. Para 59, my lord.
Yes. 59.
59, my lord.
Yes.
Page 45, my
Short paragraph.
Yes, my lord. Therefore, we can be culled out from the above is that although disputes arising purely out of contracts are not amenable to writ jurisdiction, yet keeping in mind the obligation of the state to act fairly, not arbitrarily or capriciously, it is now well settled that when contractual power is being used for public purpose, it is certainly amenable to judicial review. 61, my lord. Para 61, I would like to read out.
Yes.
Thus, the respondent could be said to have exercised power in its executive capacity as the action to cancel the tender falls outside the purview of the terms of the contract. Hence, it cannot be said that the present matter is purely a contractual dispute. It is also not a breach of contract, as no such breach has been imputed to the appellant in terms of the contract, but rather a plain and simple exercise of the executive powers. My lord, this order is a bureaucratic order in our case, for certain reasons. Page 62, para 62, my lord. Thus, the present dispute, even if related to a tender, cannot be termed as a pure technical contractual dispute, as the dispute involves a public law element. Although there is no discharge of public function by the respondent towards the appellant, yet there is a right to public law action, my lord, vested in him against the respondent in terms of Article 14 of the Constitution of India. This is because the exercise of the executive power by it in the contractual domain, that is the cancelling of tender, carries a corresponding public duty to act in a reasonable and rational manner. Thus, we find that the writ petitioner filed by the respondent was maintainable and the relief prayed for could have been considered by the High Court in exercise of writ jurisdiction. Last line, my lord. I will take 1 or 2 paras more. Para 123 of this judgment, my lord.
Para?
123, my lord. One, 3 and 124 both. Should I read out?
Yes, yes.
Before we close this judgment, we must also address one very important aspect and as regards the importance of maintaining the sanctity of tenders in public-private procurement process. Next para, my lord. Public tenders are a cornerstone of governmental procurement process, ensuring transparency, competition, and fairness in the allocation of public resources. It emanates from the doctrine of public trust, which lays down that all natural resources and public use amenities and structures are intended for the benefit and employment of the public. The state is not the absolute owner of such resources, and rather owns it is a trust. It is in trust, and as such, it cannot utilize these resources at its pleasures. As a trustee of the public resources, the state owns, number one, a duty to ensure that community resources are put to fair and proper use that ensures to the benefit of the public. Number two, an obligation to not to indulge any favoritism and discrimination with these resources. The state, within whatsoever free play it has in its joints decided to award a contract to hold up the matter or to interfere with the same, should be accompanied by a careful consideration of the harm to public interest. Next, page, my lord, 126, sanctity of para 126, my lord. The sanctity of public tenders lies in their role in upholding the principles of equal opportunity and fairness. Once a contract has come into existence through a valid tender process, its termination must adhere strictly to the terms of the contract, with the executive powers to be exercised only in exceptional cases in public authorities, and that too in loath. The courts are duty bound to jealously protect the sanctity of any tender that has been duly conducted and concluded, by ensuring that the large public interest of upholding bindingness of contracts are not sidelined by a capricious or arbitrary exercise of powers by the state. It is the duty of the courts to interfere in contractual matters that have fallen prey to an arbitrary action of the authorities in the guise of technical faults, policy changes, or public interest. Next, my lord, this para 129 on the next page, 128 para, my lord. Should I read out, my lord? Para 128, my lord. 128 and 129.
Cancellation.
Cancellation of a contract deprives a person of his valuable right and is a very drastic step, often due to significant investment having already been made by parties involving during the subsistence of the contract. Failure on the part of the courts to jealously protect the binding nature of the law of a lawful and valid tender would erode public faith in contracts and tenders. Arbitrary terminations of contract creates uncertainty and unpredictability, thereby discouraging public participation in the tenders process. When private parties perceive that their contractual rights can easily be trampled by the state, they would be dissuaded from participating in public procurement process, which may have a negative impact on such other public-private partnership ventures. And ultimately, it is public who would have to bear the brunt, thereby frustrating the very object of public interest. Next para, my lord, 129. We caution the public authorities to be circumspect in disturbing or wriggling out to its contractual obligation through thorough means beyond the terms of the contract in exercise of their executive powers. We do not say for a moment that the state has no power to alter or cancel a contract that it has entered into. However, if the state deems it necessary to alter or cancel a contract on the ground of public interest or change in policy, then such considerations must be bona fide and should be earnestly reflected in the decision-making process and also in the final decision itself. We say so because otherwise it would have a chilling effect that participating and winning a tender would tend to be viewed as a situation worse than losing one at the threshold. This final conclusion, my lord, we are of the considered opinion that litigation at hand is nothing but a now, my lord, I want to, my lord, show the petitioner has offered much more rates than they have got from other private participation. I want this is a finance matter. May I can you allow he will explain regarding my lord, what we have offered, what they have got from other parties.
Yes, going on the arbitrariness. You see, the thing is that the jurisdiction of the action regarding the price, the details. We are not
my lord,
only your questioning is the arbitrary action of the respondent in a duty executed contract where they've just retracted from it without any use or reasonable reasons.
Madam, my lord, they have not considered manpower, operational cost, construction cost. Nothing sort of they have considered into while cancelling the contract. The petitioner had to incur hundreds of crores in construction, manpower, and etc. after obtaining this contract. Now, my lord, this is the ruling of Supreme Court, Mihan. देना जरा निकालो और कोई बात नहीं ये नहीं है ठहरो नहीं ये तो ये माय लॉर्ड को इसकी दे दी ये दिया कि ये दिया तो फिर कैसे हाउ यू विल कंपेयर यही तो अच्छा पैरा सेम this my lord Supreme Court ruling squarely covers my case. I want to draw your kind attention, my lord, to certain paras.
Yes.
Mera para 5, my lord. Page 3, my lord. Briefly, the facts relevant to for the purpose of these appeals are that Nagpur International Airport, Nagpur for short, Nagpur Airport was being run by the Airport Authority of India on the initiative of Government of Maharashtra, the GOM, to develop a multinational international passenger. On the initiative of Government of Maharashtra to develop a multi-modal international passenger and cargo hub airport at Nagpur for brevity's sake, referred to as Mihan. In coordination with Government of India, for short GOI, Ministry of Civil Aviation, MOCA, AI and Indian Air Force through Ministry of Defence has prepared the report for Mihan project. On 18th December 2006, Government of India through MOCA and AI on one side and the Government of Maharashtra and Maharashtra Airport Development Company on the other side entered into a memorandum of understanding for the purpose of establishing a joint venture company and transferring the airport to the SAT JVC to develop into Mihan. As per the SAT MOU, MADC shall have 51% of the equity and AI 49% equity of the JVC. Pursuant to the MOU, the AI and MADC entered into a joint venture agreement on 22nd February 2019 for the purpose of incorporating a JVC which is known as MAL. As per terms and conditions of the MOU dated 18 December 2006, JVA dated itna, ML took over the airport from Airport Authority of India on 7th August 2019. Para 8, my lord. No. Page कौन सा? Page 6 my lord. May I read, my lord?
Yes.
Even on completing the said formalities, the concession agreement was not executed for a long time, my lord. In my case also the same facts. Letter of award was issued, but agreement.
But in these cases was the contract awarded to someone else?
In Mihan? No, sir. No, my lord. It hasn't been awarded to anyone. It also been kept in abeyance, and what has happened that they have cancelled the whole process, and then they went to again the Government of India for reissuance of tender under the process. So there's a minutes of meeting which has concluded.
May I read out, my lord?
Yes.
Even on completing the said formalities, the concessions agreement was not executed for a long time. However, on 25th February 2020, requests were made by GAL to MIL for execution of concession agreement so as to enable GAL to implement the Mihan project. Next para, my lord. Para 9, there is a prayer clause, my lord. Para, next page, my lord. Page 8 with prayer is there, B. In small letters, my lord.
Yes.
Issue a writ or any other appropriate writ, direction or order directing the respondent to comply with the RFP, condition its letter and spirit, and undertake necessary and consequential steps in furtherance thereto. And the letter of award dated 7th March 2019, including but not limited to the execution of the concession agreement in favor of the petition number 2 and other ancillary documents. Now, my lord, page 12. Para 12, sorry.
Yes.
The Nagpur bench of the Bombay High Court, by impugned judgment dated 18th August 2021, allowed the writ petition and held that the letter dated 7th March 2019 is a LAO. Plea taken by ML that letter dated 7th March 2000 is a mere communication of bid acceptance is not correct. In our case also they say it is a letter of award is a communication only, which is not correct to us. In fact, it is led to a concluding contract between the parties. Number 3, the action of ML in annulling the bidding process by letters dated 19th March 2020 is arbitrary, unreasonable, unfair, therefore quashed and set aside. 4th, in this case, there are no such disputed question of facts as would shut out the writ jurisdiction of the High Court. Number 5, this case does not involve a mere enforcement of contractual obligations simpliciter, but invokes an issue of enforcement of public law arising out of a contractual obligation. Resultantly, the High Court gave a direction to take further steps to implement the prayer as made in clause B of the prayer clause of the writ petitioner. Para 42, my lord, 15.
Para 42.
42. No? Page is, my lord, 47. Supreme Court,
47.
42.
Yes.
Now, as per the material available and discussed herein above, it is clear that the appellants were aware of the procedure which is being adopted.
Yeah, after completion of
the bidding process, GAL was declared as a selected bidder on offering highest revenue share and on issuance of LAO.
Yes.
It has been declared as a concessionaire, and at the stage of execution of concession agreement, all these formalities are not relevant, and it amounts to arbitrary exercise of power by the authorities, which is not permissible under law. The said approach is fortified by Malat. This one. इसके बाद में कौन सा पढ़ना है पूरा? Next. Para 46, my lord. 44. 43. 46, my lord. Page, my lord, 52.
Yes.
Have you got, my lord?
Yes, yes.
In view of the above, it is apparent that in government contracts, if granted by the government bodies, it is expected to uphold fairness, equality, and rule of law while dealing with contractual matters. Right to equality under Article 14 of the Constitution of India adores arbitrariness. The transparent bidding process is favored by the court to ensure that constitutional requirements are satisfied. It is said that the constitutional guarantee as provided under Article 14 of the Constitution of India demands the state to act in a fair and reasonable manner unless public interest demands otherwise. It is expedient that the degree of compromise of any private legitimate... Right. 49, my lord, now. Page 54, my lord.
Yes.
In the facts and circumstances of the case and the findings so recorded herein above, it is clear that the authorities have acted arbitrarily in violation of Article 14 of the Constitution of India. In such a situation, the public law remedy has rightly been availed, invoking the jurisdiction of High Court under Article 226 of the Constitution of India. The findings recorded by the High Courts to entertain the petition in paragraph 95 are just and proper, and we are in full agreement to those findings. In the facts of present case, the arguments advanced by the appellants to compel GAL to take the remedy of specific performance under the provisions of Specific Relief Act is hereby repelled. My lord, on the last date, they were asking me to go in specific performance. This is the answer for this. There. Next, my lord, para 51. This is the last para.
Yes.
From the above, it is clear that in pursuant to the decision taken by the cabinet, the second JV is required to be selected through competitive bidding. In the present case, global tenders were invited and competitive bidding process was followed. The process of issuance of LO is completely a fair procedure as prescribed in our RFP. As per the decision taken by MOC, AI and MADCL ML is the authority to complete the bidding process, and PMIC acting on behalf of the government of Maharashtra was supervising the entire process. The annulment has been directed in reference to letter dated 16 March 2020 for retendering of bid. Therefore, in issuing the annulment letter, there is no law of Union of India and AI. The serious objections has been raised regarding grant of relief as prayed for in Clause B by the High Court. In this regard, we examine the said relief and direction as issued by the High Court in terms of the cabinet decision. We are satisfied. All right. So, my lord, this is Supreme Court has affirmed the view of Nagpur High Court. All right. This squarely covers my case, my lord. And as far as my lord revenue generation is concerned, our company is not going to cause any loss. Rather, with the MAPTCL would be beneficial if they calculate their the money to be spent on manpower, operational, and other construction costs, etc.
Yes. Thank you.
Thank you, man. My lord, I have made a brief note in the shape of written submission. If you say, I'll put it. Otherwise, there's no necessity at all. Otherwise.
Yes.
For guidance, may I issue you, my lord? If you want to look into, you look into. Otherwise, you don't look into. Which one? Written synopsis I have made. It may help you or it may not help you.
Yes, you keep supply it.
Thank you, my lord. Thank you, my lord, for patience hearing, my lord. Thank you very much.
Yes, my lord. Now, my lord, the challenge before your lordship in the instant petition is the letter of the respondent, my lord.
Yes.
Impugned letter is at page 60, by which the letter of award has been cancelled.
Yes.
Kindly see the impugned letter, my lord, first, and then I will take your lordship to the letter of award and the relevant terms of the tender.
Yes. Yes.
Page 60, if your lordship kindly see.
Right. Yes. I've got
it. Says, page 60, resolve that in supersession of earlier resolution number 6 passed by the Board of Directors in meeting held on 17th November 2023, Board hereby decides to cancel the letter of allotment dated 29th November 2023 issued by Messrs. Sterlite Interlink for monetization of OPGW assets of MEPTCL. Lordship may kindly mark monetization of OPGW asset. This is my asset, which was I was trying to get it monetized through MEPTCL, my lord. Now, if your lordship will kindly see the letter of award, my lord, which is at page
150.
Yes.
150.
Yes. If4, yes.
In letter of award, my lord, 150, my lord.
Yes.
The paragraph 5.2 says, my lord.
Yes.
There are certain provisions which your lordship will kindly see. First, 2.0.
Yes.
And 2.3 is a relevant clause, my lord.
Yes.
The letter of award is subject to terms and conditions detailed herein under, my lord. One, work under this LOA shall be performed by the firm strictly in line with bidding document and contract, except as strictly amended, modified in this letter of award, my lord.
Yes.
The ownership of OPGW asset under the contract shall rest with MEPTCL. Our on behalf shall take full responsibility for it. But kindly come to the most relevant clause, 5.2, my lord.
Yes. Yes. Enter formal.
It says, my lord, You shall enter into formal agreement with MEPTCL within 15 days of issuance of letter of award. The
How do you explain
infrastructure
How do you explain 5.1 then? If they say that notwithstanding anything as stated in the bidding document, this LOA will constitute the formation of the contract. What do you answer by formation?
Yes,
Formation means that
yes,
the contract is
Yes.
executed. Yes.
Yes, there are two parts. First part is that letter of award, and after letter of award, Milord, it leads to signing of a separate infrastructure asset management agreement. Milord, you also kindly see paragraph 5.2.
Yes.
You shall enter into a formal contract with MEPTCL within 15 days of issuance of this letter of award. This infrastructure asset management agreement shall be prepared by you in 2 copies and completed at your cost per performer given in Schedule 4 of the bidding agreement. And then, Your Lordship, it's the requirement is, my Lord, that there has to be signing of infrastructure asset management agreement.
Yes.
That agreement has never been signed, my Lord. Now the question is, before signing of infrastructure asset management agreement, letter of award has been cancelled. Question which falls for Your Lordship's consideration is whether it can be cancelled by MEPTCL for cogent reasons or valid reasons or not, whether LOA is final document and therefore the MEPTCL has no right to cancel the
LOA.
and MEPTCL has no right to say that it will not enter into infrastructure asset management agreement.
Yes.
So these are the two issues which fall for. Kindly see the terms of the bid document, my Lord, because LOA has been issued in terms of the bid document. And that page, Your Lordship will see page 77, clause 3.20.25.2, my Lord.
Yes. Yes.
The MEP reserves the right to accept and to annul the bidding process. My Lord, kindly mark these words. MEPTCL reserves the right to accept or reject any bid or to annul the bidding process and reject all bids at any point prior to award of contract without there being incurring any liability to affected party or bidder or any obligation to inform the affected party or bidder of the ground for MEPTCL action. So the bid document, in my humble submission, reserves the right to the petitioner, to the respondent, to annul the bidding process, my Lord. So the first question which, my Lord, I am answering is that the bid document gives me right to annul the bidding process.
Prior to
and I am entitled to exercise that right, and I have exercised that right, my Lord. That is the first thing which I am placing for Your Lordship's consideration. That which this confers me right to do it or not. Now the question which falls for Your Lordship, second question which, my Lord, is also in the contract has not been signed between the parties, my Lord. And Your Lordship has seen 3.2.2, then kindly see, my Lord, one more clause, 3.2.4 C, my Lord, at page 78. 3.2.25.4 subclause C, my Lord, at page 78. The successful bidder will prepare the infrastructure asset management agreement as per prescribed performance, and same shall be signed within 15 days of notification of award or within such periods as extended beyond 15 days as agreed amongst the parties, but not more than 30 days after notification of the award. Failure to do so may be construed as successful bidder's default, my Lord. So the period contemplated in the bid document is that it has to be signed within 15 days but it can be extended by up to 30 days. And admittedly, there is no extension of the letter of award by the parties. There is no such agreement between the parties. No material has been placed by either of the parties showing that this clause, by virtue of this clause, the letter of award was extended or infrastructure asset management agreement was signed between the parties. So as of today, my Lord, admittedly, there is no infrastructure asset management agreement, and it was required to be signed within period of 30 days. That is, so I make two submissions based on the bid document, my lord, that the respondent, any petition reserves the right to annul the bidding process at any stage. My lord. That right was there. Now the question which falls for lordship's consideration, whether there is an arbitrariness in exercise of said power.
Yes.
My friend
That's important one you answer, yes. Why did you
that
go into the
is-
why did you go into the entire bidding process if you wanted to cancel it? Only thing. Yes.
My lord, if during the course of bidding process and after assessment, my lord, if it is discovered that it is not beneficial to the respondent, the question arises whether the board has competence or the power distribution
Right.
company has competence to cancel it. Now, your lordship kindly see the paragraph 18 which was read out to me, but
Para? Yeah, what?
one page, my lord. One page 64 also, my lord. Kindly see page 64 also of the bidding document. This is also with the background why it was cancelled, my lord.
Yes.
Any petition has a total OPGW of optical fiber network, my lord, for my understanding, 665 kilometer on its 132 kV and 202 kV transmission line, which includes the already installed a OPGW network as well as OPGW network presently under the construction, and now any petition proposes to lead out spare dark fiber on its cumulative OPGW network to the licensed telecom service provider. So I will give it to the licensed telecom service provider for optimum utilization of its infrastructure asset and to further ensure its maintenance as well as generation of additional revenue. Any petition intends to select an exclusive operating partner and grant right to maintain and operate STU, a OPGW assets, and perform all customer lifestyle activities in order to enable any petition to monetize the infrastructure asset by leading to the communication service providers. Now, the purpose of this tender was, my lord, that I have the asset. This will be monetized by the petitioner before your lordship, and the revenue will be earned. That was the object.
No,
of
see,
the tender.
what the understanding of the court is that what drove you to decide to come this decision is that after you monetize it, after the bidding process had been gone through,
correct,
you found that you'd be making 1 crore, you're making 6 crores. That's the only thing.
So this is the Milord. Ultimately, if
There's no scope for negotiations of the bidding process. If you'd gone through the
there is
bidding,
no Milord, because I can't do the post-tender modification of the bidding also, Milord. Once if there is a terms which are laid down, kindly see page 42 of my counter affidavit, Milord. Page 42 where the discussion is with regard to monetization aspect. Page 42 of my counter affidavit. There were three scenarios which were placed before the board of directors.
yes.
Case number 1, Milord, if your lordship kindly see the table. Case number 1. Calculation of revenue to ME petition on monetization of 8 fiber pairs on the existing route of 641.07 km. Table A, Milord. OPGW route length, serial number 1, your lordship has noticed that 641 investment of any PTCL, Milord, is 54.81 crore rupees. So I have already invested 54.8 crore rupees.
It's already invested. It's already invested. Even it's already in the ground.
This is already on the ground. 641 kilometer is already on the ground, Milord. And my investment is 54 crore rupees already there, Milord. Now kindly see investment by the investor line, that is petitioner, Milord, nil. Expected revenue to SIL, Starlight Interlink Limited, say per pair kilometer is 7 crore rupees, and expected revenue to any PTCL based on 5% of revenue sharing model is 0.35 crore rupees, Milord. So from my investment, this SIL will earn 7 crore rupees and I will earn 0.35 crore rupees. First scenario, annual charge, Milord, to be paid to us, Milord, and total earning I will have, Milord. Kindly turn over the page at page 43 of scenario 1, that is 7 crore rupees will be earned by Sterlite, and I will earn 1.55 crore rupees on my investment, my lord. That is 54 point. Now scenario number 2, my lord. Calculation of revenue of METCL on monetization of 8 upcoming routes. My lord, this is the upcoming. Now first was already investment and second is upcoming, my lord. Now, in this, the Sterlite is likely to make investment of 18.18 crore rupees. Expected revenue to me will be, my lord, 0.12 crore rupees and 2.32 crore rupees will be earned by Sterlite, my lord. And then, this is also not favorable to me, my lord. Kindly see third case number 3, my lord.
Yes.
And case number 3 is that I will be earning 7 crore rupees if I directly lease out the lines to the telecom companies, my lord. It is my asset and I have to lease out. And scenario number 4, my lord, when this with regard to future, I will make investment of 18 crore rupees and I will get the return of 2.32 crore rupees, my lord. Now kindly see, the following can be inferred from table A, B, C, D. Table A, 100% monetization of assets on existing OPGW route. Revenue accrued to is 1.55 crore per annum as opposed to aside earning of 7 crore considering the leasing of 8 so and so. Table A and B with minimum 100% monetization of assets on the existing as well as upcoming OPGW route. Revenue accrued to MEPTCL is 2.7 crore rupees. And considering the lease of 8 power is so and so. Table A and B considering capital expenditure of 54.81 crore rupees of MEPTCL. Break-even period for MEPTCL for recovering is 27 years, my lord, and the life of the optic fiber is not more than 10 to 15 years. So I will look the table C and retain assets and liabilities, and break-even will be achieved by 8 years, my lord. Retain the assets and lease and subsequently break-even period. So these factors, my lord, weighed with the board. Next page.
Yes.
Kindly see the next page also. He said that from the above it is seen that monetization of MEPTCL or OPGW mode is less beneficial compared to leasing the same differently vendor by MEPTCL as a part of telecom business. Moreover, lifespan of OPGW is 15 years, whereas proposed period of agreement is 20 years. In the light of the following proposals are placed before the Board of Directors for consideration, Board may perhaps consider expert opinion on the matter. Board of Directors may perhaps consider legal opinion. Board of Directors may perhaps consider leasing out OPGW fiber, such as expression of interest can be sought telecom players, which may foster competition and ensure consumerate and enhance return of MEPTCL. Board of Directors may perhaps consider maintenance of OPGW carrier communication subdivision under the so and so law. The chairman sought the opinion of Sri L. M. Sarma, director, if so and so, and then the rightly so opinion has been given that we would not like to proceed because it is not beneficial to the public interest. It is my property, it is my investment, and they have no vested legal right. The legal right has only they have submitted the bid and their bid has been accepted. So at that stage, my lord, I am assuming, my lord, that even the agreement has been. I take the case further, my lord. This is a case of if the agreement of infrastructure asset management agreement has not been signed. Even assuming it has been signed, my lord, whether I have a right to terminate the agreement or not under 14(1)(d) of Specific Relief Act, I have a right to terminate. That stage has also not reached, my lord. So my humble submission is that there is no arbitrariness whatsoever. I have taken into consideration the benefit of the public money, and decided not to go ahead with the tendering process, my lord. And if your lordship will see my counter affidavit where I have cited the relevant judgment and case law on these aspects of the matter, my lord. Kindly see, everything is there in my counter affidavit, my lord. I need not take, because all these judgments I have been citing time and again before your lordship in various matters. But if your lordship will kindly come to page 4.3, my lord. 3, which I have already, paragraph 5, I have already shown, my lord, in detail, my lord.
Yes.
And paragraph 6, my lord. the first objection to the maintainability of writ petition which I have taken, my lord, is may not issue writ of mandamus for a specific performance. What my friend is asking this honorable court, or praying to from this honorable court to direct the respondent to enter into infrastructure asset management agreement, my lord. So there cannot be a specific performance. Now, my lord, those objections which I have taken, then your lordship kindly see the clauses which I have already relevant clauses are at paragraph 9, my lord. Paragraph 9 of my counter affidavit, my lord, where I have given in detail the requirements and everything. And then, my lord, kindly come to paragraph 18, which I have already shown to your lordship. The paragraph 18, the rationale for cancellation of the monetization aspect, which I have already shown through the annexure, my lord. And 19, my lord, is also in favor of that, my lord. So, in my humble submission, my lord, the issue is not of arbitrariness on the part of the respondent, my lord. If the decision has been taken in the public interest, they have no wasted right, my lord, in law. And you will also kindly see the judgments which I have already cut out in paragraph in my counter affidavit, my lord. I am not repeating the same for the sake of brevity, my lord. Your lordship may kindly refer to these paragraphs in case law. And the case law cited by my learned friend are distinguishable on facts and on law both. In those cases, the fact situation was not this, that the benefit was larger to the private entity and to the government, my lord. My friend is questioning also if there was a feeble attempt to was made to question the financial wisdom of the respondent, my lord, that no, they will have to incur more expenses, etc., in maintaining the optic fiber. I have already made 54 crore rupees of investment, my lord. I will be getting 1.5. The petitioner will be getting 7 crore rupees per year, my lord. This kind of financial arrangement, my lord, cannot be allowed to be perpetuated as it would lead to loss of public money, my lord. This is all I have to submit.
Okay, you reserve judgment.
Madam, my lord, I want to point out certain things. Commercial viability, कौन सा था पेज, कौन सा था 3 point?
Yes.
ये निकालो, इसमें से निकालो ना यार. The commercial viability was already done.
Commercial viability will not.
They have already calculated, my lord. They at the time of issuance of tender document, yes, commercial viability and everything was seen by them, calling the bidders. It was calculated. This is minor financial eligibility criteria. Commercial evaluation of bids were done. This is para 3.23, page 76 on tender document, my lord. And similarly, my lord, details of commercial bid were also discussed 3.22.1 in the tender document itself, page 75, my lord. Why it is they are doing 3.22.1 and 3. Commercial valuation of bid was also done in the presence of two bidders.
1.5 CR.
Fixed annual amount is, my lord, the figures which they have hypothetically mentioned in the counter affidavit,
the
table, they have not shown the operational cost, manpower cost, structural cost. They have not mentioned at all. They have not taken into consideration these factors.
Yeah.
So this is my humble submission that, my lord, this is arbitrary action of the respondents.
Thank you.
Thank you,
my
lord.
Yes.
Thank you.
Yeah, you give that.
Because it is not. It is.
No, you give it. Give it.
Thank you, sir. Hello. This is for, my lord, if you want to take help. No. Otherwise, it's not an important document.
No, I've heard you. We will examine it.
Just an excerpt of my lord, what my sir has argued. That's only.
Yes.
The written submission is only the excerpts of what.
Of course. Thank you.
Keep